We're in the record. Good afternoon. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Code Section 2571 of the Open Meetings Act, I am welcoming you to the regular scheduled meeting of the Alcoholic Beverage Cannabis Board. This meeting is being conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central meeting calendar. The notice included the time, date, agenda, and call-in or login information for public participation. This electronic meeting is being hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your name. Mr. James Short.
Mr. James Short, present.
Mr. Bobby Cato.
Bobby Cato, present.
Ms. Jenny Hansen.
Jenny Hansen, present.
Mr. Edward Grandis.
Edward Grandis, present.
The board has 5 members in attendance for the conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of this hearing is understood by everyone. There are actually 2 cases scheduled for today. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. At the conclusion of each case, the party will have the option to leave. The party chooses to stay on camera and microphone. All cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Before we get started this afternoon, I would like to take a moment to say a few words about our fellow board members, Bobby Cato, Jenny Hansen, and Edward Grandis, and thank them for their service on the board. Today is their last day on the ABCA board, so this afternoon is bittersweet for me and for the members of the board. Bobby has been an important member of the board over the last 5 years since joining the board in January of 2018. As a Ward 5 resident and a background in real estate, Bobby has brought a beneficial perspective to the board in rendering its decisions. Jenny and Ed deserve credit for being able to succeed after having had the difficult task of joining a new board in the first quarter of 2020 during the start of the life-changing COVID-19 pandemic. Ed, Jenny, and Bobby played a significant role in balancing public health and safety during the pandemic, while finding innovative ways for alcohol establishments to operate safely. The district owes them a debt of gratitude for helping the board navigate the pandemic. Despite being in the middle of a pandemic, Bobby, Ed, and Jenny embraced the board's new role in October of 2020 of being responsible for the district's medical cannabis program. Bobby, Ed, and Jenny took this new responsibility seriously, immediately listening to stakeholders and licensees regarding changes needed to the program. Bobby, Ed, and Jenny worked with the board to make significant necessary changes to improve the program. Throughout their time on the board, Bobby, Ed, and Jenny have brought a balanced approach to the role of a board member, taking into account the needs of both businesses, ANCs, and residents. The efforts have helped the board represent the best interests of the District of Columbia. The board and ABCA cannot thank you enough for your contributions as board members. We will miss all 3 of you generally. Please stay in touch. If each member would like to say something, I'll give you an opportunity to speak. And I'm going to go in seniority. And so in seniority, in the sense that Jenny, I'm sorry, Ed would go first in seniority, in the sense of the the last person to have joined the board, and then we'll move. So it would be Ed, then Jenny, and then Bobby. So if you want to say something, Ed, please.
Mr. Chairman, I want to thank you for the wonderful words that you spoke about the role, not just of Bobby and Jenny and myself, but the whole board together collectively fulfill that role. And I want to thank you very much for putting that in the record. I also want to admonish you because age, I think, is a privacy matter. So I may be seeing you in one way, but I think Mr. Short has seen you in other ways of being a lifer on the board. But what I really would like just to say to the public is that our work is a challenge because we have to balance, as the chairman mentioned. Our work is made a lot easier and understandable for the public because of the hardworking staff and legal office and the director provide the board almost on every day on matters that come before us on typical Wednesdays. So I want to make sure the record shows that we as board members appreciate the very hard work, many hours, some weekends, I'm sure, that our staff has to perform so that we do a good job. So thank you, Mr. Chairman.
Thank you, Mr. Grandis. Ms. Henson?
Thank you. I want to thank everyone here, my fellow board members, and also the mayor for the opportunity to serve the city. It's been a great pleasure and honor to work with you all. And I just want to say thanks also to the agency staff who's been wonderful. You all will be missed. Thank you.
Thank you, Ms. Henson. Mr. Cato?
Yes, I want to take this opportunity to thank as well as the agency for having faith in me to serve on this board and serve the city, the residents of Washington, D.C. over the last 5.5 years. Thank you for this opportunity and appreciate it as well. And that's about it.
Thank you, Mr. Cato. I mean, one thing that we've done today that we have not done since the onset of COVID is that the board, 4 of us we're meeting here in person. So that's one of the reasons why you might see that we're all wearing headphones, because we're actually in the boardroom sitting on the desk to do this hearing today. And it is, as I stated before, the last time the board met in person was I believe in March of 2020. So today is the first time that we're meeting in person since that time. All right, so let's move on to our calendar. The first matter on our calendar today, it's show cause here in case number 23 CMP 00056 Bluestone Lane, license number 114952. This case has been canceled due to the approval of an offer in compromise. See board order number 2023-529. The next case in our calendar, we have another show cause hearing. Case number 22 CMP 00084 Flash Catering, license number 105744. Good afternoon, Mr. Oriana. Can you please elevate the rights of the government and the licensee in this case?
Good afternoon, Chairman. Anthony Sello, your access has been elevated. Afshin Motagi, your access has been elevated. Andrew Klein, your access has been elevated. Cameron Mixon, your access has been elevated. Investigator Jeremy Zollerkoffer, your access has been elevated. And Nayef, your access has been elevated. That is all, Chairman.
Thank you. All right, good afternoon, everyone. All right, so let's start with to have the parties identify themselves for the record. Let's start with you, Mr. Klein.
Good afternoon, Chairman Anderson, members of the board. Andrew Klein of the Veritas Law Firm on behalf of the licensee.
Good afternoon. So let's have Mr. Nayef, please spell, I'm sorry, go, Mr. Mixon, please identify yourself for the record, please. You're on mute, Mr. Mixon.
Cameron Mixon with the Veritas Law Firm, CameronMixon.
All right, thank you. Mr. All I see on my screen, Neff, so please spell and state your name for the record, sir.
My name is Naif Issa, and spelling is Nayefissa.
Is that your full name, sir? And what's
Naif.
your relationship to this establishment?
I through an event there.
Sir, sir, what is your? I'm sorry, Mr. Klein.
He'll be a witness for us today.
I apologize. Okay, so who's the licensee? Mr. Klein?
Mr. Matagi.
Mr. Matagi, can you spell and state your name for the record, please?
Yes, sir. Afshin Matahi. First name is AFSHIN. Last name is MOTTAGHI. I am the license holder.
All right, thank you. Mr. Thilo, can you spell and state your name for the record, please?
Assistant Attorney General Anthony Cello on behalf of the district. ANTHONYCELO.
If this matter goes to a hearing, do you have a witness you wish to call, Mr. Cello?
Yes, if I am required to call a witness, it would be Investigator Zollerkoffer, although I think one of the preliminary matters will absolve that need.
Sure, that's fine. All right, so as I said before, this is a show cause hearing. Are there any preliminary matters in this case, sir?
Yes, Mr. Chair, there are several preliminary matters. First,
before we get to that, Mr. Chair, if I may, and I tried to do it. I tried to do it earlier. I don't want to do it in the middle of the case, but I did want to take the opportunity to thank Mr. Cada, Mr. Grandis, and Ms. Hanson for their service and for their engagement, not just their service, because as this board knows, it requires a great level of attention and engagement to participate in these hearings. I've been before you many times, perhaps maybe more than anybody else other than the government. And I appreciate the three of your participation, your willingness to stay until literally all hours of the night without any discernible drop off in attention. It's really appreciated. And look, I'm not going to say I always agree with the decisions that are made by the board, but I can say that we've always gotten what I thought was a fair hearing. And I know the residents of the District of Columbia and businesses in the District of Columbia appreciate your service and the time that you spent on the board. So I didn't want this to pass without taking the opportunity to say that. Thank you.
Thank you, Mr. Klein, for that. All right, Mr. Phil, are there any preliminary matters in this case?
Yes, First District echoes Mr. Klein's statements wholeheartedly. There are several preliminary matters. First, the district is withdrawing charge 2 based on newly provided information after the charges were filed. However, we are still proceeding with charge 1 in this matter. And just for reference, charge 2 was the certificate of occupancy. Charge 1, which we are proceeding on, is the operating beyond the scope of the license.
Thank you, sir.
Second, we do have a stipulation to the facts contained within 22 CMP 00084 investigative report. And I would note that that's already admitted into the record as a matter of law.
That's fine, sir.
Right. Third,
that's agreed.
Third, I request that this board take judicial notice of and put on the record the investigative reports, OICs, and orders accepting the OIC for the relevant prior cases, numbers 22-251-0002 and 22 CMP 00018.
So moved.
Mr. Chairman, I have an objection to that. We haven't agreed to that, and I would question the relevance.
What is, I thought that there's still a stipulation. So what is it that You're asking the board to take it to judicial. What were you asking the board again to do, Mr. Silo?
Take judicial notice and put onto the record the prior cases involving Flash Catering and the charge of operating beyond the scope of their caterer's license. There are two recent prior cases, 22-251-00002 and 22 CMP 00018, involving and specifically the orders accepting the OIC, and the investigative reports from those two cases.
Mr. Klein, I mean, of course, if they're part of the board's records, they're part of the board's records. If that
doesn't make them relevant, Mr. Chair. I mean, there are many things that are part of the board's records. They're certainly relevant for determination as to if the board were to find the respondent liable. They're certainly relevant for purposes of determining what the appropriate penalty might be in terms of how many prior primary tier violations there might have been within a certain period. But other than that, I'm not sure for what purpose they're being proffered.
All right. Well, if the parties do not stipulate to this factual then then it's not. I'm not going to accept it as a stipulation. So let's. I just want to make sure that I'm clear what it is that the parties are stipulating to.
And I do want to make it clear that I was not suggesting that was a stipulation. I am asking the board to take judicial notice of its past orders in the past cases involving Flash Catering and this exact charge.
Okay. So noted. Okay.
Mr. Chair, I do have to ask, it was noted, is the board going to take judicial notice? Otherwise, I will have to put on evidence of that to support the record.
I mean, I think all right. It's my understanding, at least the proffer that's placed, that factually, the facts are not being contested. So it appears that what this board is asked to do is to determine what penalty, if any, should be assessed to factually the factual case.
Oh, that's not correct, Mr. Chair.
Right.
That's not correct at all.
All
We're
right,
not
sorry.
conceding the violation. We're only stipulating that the facts set forth in the report are stipulated to for purposes of dispensing with the need for testimony. But in terms of the violation, and we'll get into this in a minute, I don't even know what it is, to be perfectly honest.
Then that's incorrected then.
And with respect to administrative notice, we don't just take administrative notice because it's part of the board's records. It needs to be in some way relevant to this case. And we have yet to hear a proffer as to for what purpose the board is being asked to take administrative notice. As I said, we have no issue if they're being taken in administrative notice of for the purpose of determining the appropriate penalty. But if it's beyond that, we would ask that there be a proffer and probably have an objection.
And I can make that proffer, Mr. Chair. I'm happy to do so.
All right. Hold on. All right. Are we having a hearing today? Because I'm confused. I thought that I thought preliminarily that the parties had come to some agreement and that the board would be asked to make a determination whether or not the licensee is liable or not liable for the infraction based on the arguments that are made, penalty. Now, if that's not so, then we need to hear factually what the violation is, and for us to make a decision whether or not the board believes that the licensee committed the violation and what penalty, if any, should be assessed.
We are going to have a hearing today. Yes,
All right.
Mr.
All right, fine. So because
But I didn't understand the difference between the first and the second, frankly. I mean, we have a stipulation on the facts. So at least as far as the report goes. So yeah, I mean, the question is, do the facts as set forth in the report and or even the notice of show cause set forth a violation of the ABC laws or regulations. In our minds, that's what the issue here is.
And Mr. Chair, specifically because opposing counsel has raised the concern that they are not even aware of what the previous violation or what this violation is. The fact that they have accepted an OIC twice before for the exact behavior on this exact charge disproves that claim. That is why I'm asking the board to take judicial notice of the past cases, the orders that it put into place on those cases.
Mr. Chair, those are offers in compromise. If it's going to be the position of this board that when one accepts an offer of compromise, an offer in compromise, that means not only are they guilty, or not only they're liable, to use the correct term, not only are they liable for that violation, but they're liable for all future violations. That's
That is a
violating
gross
public policy.
mischaracterization.
Excuse me, please. Because I certainly won't be recommending, if that's the board's position, I won't be recommending that anyone else accept an offer in compromise. It's an offer in compromise. It's a settlement. And to say that that's somehow evidence of something in this case, that's not supported by law. That can't be.
All right. I think for the board to make decisions, let's have a hearing. Let's call a witness. And the witness can testify, and then the board will have a full record to make a determination. Because I'm not hearing, it doesn't appear to me that there is agreement between the parties about where we stand. So if there's no agreement, then let's move forward with a hearing as we would in all the other cases. If there's if they're saying, if the parties have agreed that the facts in the case report is uncontested, then we can probably have a proffer of what it is that's uncontested, and then we can have testimony on other issues. So at least we'll have a record of what the facts are. Is that agreeable?
Yes, Mr. Chair.
Yeah, that's agreeable. I mean, as I said, we've stipulated to the report. I don't think there are any facts in dispute as far as the report goes at this point.
All right. So, all right. Does the parties wish to make an opening statement?
Yes, Mr. Chair.
Go ahead, sir.
May it please the board, Mr. Chair, ladies and gentlemen of the board. This case involves a licensee that was in flagrant violation of this board's orders continuously for nearly a year. This licensee was charged for incidents stemming in February on 2 different occasions. One of those charges in both cases was operating beyond the scope of their caterer's license. What they were doing was operating a nightclub out of a venue in continuous operation. And they stated that their intended plan was to continue this operation through December of 2022, at which time they would be opening a brick and mortar establishment. In the first 2 cases, they pled through an OIC. They were found.
Mr. Chairman, I hate to object during the opening, but I must vehemently and strongly object, as I've indicated before. What they did in an offer and compromise is completely irrelevant. And if this board is going to start taking evidence of that, I can tell you there will be no more offers and compromise out of my office, because that's outrageous.
Mr. Klein, the attorney is giving his opening statement. I mean, an opening statement is not evidence. you're aware that an opening and a closing is not evidence, sir. These are just statements that are being made by the attorney, and so he's making his opening, and so we will see whether or not the presentation, what will be presented to the board for the board to make a determination. But as opening statements are not, I mean, that's not evidence. It's just
it's extremely prejudicial though, when it's improper.
Well, I well, I what I have as part of this case, I do have the investigative history, and the board will take the investigative history for what it is. So the board has access to the investigative history of this facility, and of course, if the board determines that the licensee is guilty of the infraction, the board will have to look at the investigative history to determine what the penalty is going to be. So I mean, he can continue with his opening statement. So again, it's just an opening statement. It's not factual. I'm sorry. It's his opening. Okay, this is not testimony. So go ahead, sir.
As the evidence will show, after the OIC was submitted in both cases on 9/14/2022, on October 21st, 2022, investigators Puente and Zollicoffer returned to the establishment and found that they were still continuing their operations of a nightclub using a caterer's license. Again, they were told that this is operating beyond the scope of a caterer's license, and again, a charge was issued. In response, they were told that the establishment had to keep operating in order to keep making money and had to book talent to stay relevant in the industry. This establishment continued their operation through December 2022 in this manner, despite twice accepting OICs and paying fines for violating this statute, for operating beyond the scope of their caterer's license. We are here for a third violation. And as I anticipate, opposing counsel is about to say in his opening argument that they have no idea why these charges have been filed, I would note that the continual daily operation of a nightclub, offering 6, 7, 8 different events per week, is a violation and is operating beyond the scope of a caterer's license. Such operation requires a nightclub license. That's why it exists. And that is what this case will be about. Thank you.
Thank you. Mr. Klein.
Mr. Chair, at this time, I would move to dismiss the charge. There is nothing, there are no facts that are stated in the opening that would give rise to a violation of 23 DCMR 2000.1, nor are there any facts set forth in the notice giving the licensee notice of what it is in violation of. All we have is that they're operating beyond the scope of the caterer's license. But there are no facts that are presented. The only facts that are presented are, well, they pled to it before, so they must be guilty now. That is the sum and substance of what the government has said that they will prove. They haven't referenced any of the provisions of 23 DCMR 2000.1, nor are any referenced in the notice. So, is this about not enough food? We don't know what this is about. I mean, they pleaded twice before, so they have to be guilty. That's not enough. Due process requires that one, before the board be given, or before any administrative agency or court for that matter, be given notice as to what it is they're accused of having done or not having done, and simply saying, well, they know what they did wrong because they accepted responsibility for it before. That throws the whole notion of an offer in compromise or a settlement on its head. Because that means rather than a licensee or a private litigant entering into a settlement where they agree to get rid of the charge, they have to worry about someone's going to conclude after the fact that that means that they admit all future violations as well, potential violations. And that's just wrong. But most importantly, we haven't been, there are no facts that have been alleged that would give rise to a violation under 2000.1. So we would ask that it be dismissed.
Well, I think at this juncture, Mr. Klein, your motion would be premature. We haven't heard. I don't know what this case is about. I'm waiting for the testimony to for witness to testify, and so I believe that after the witness has testified and the government has rested its case, I believe that if you want to make a motion, that would be the appropriate time to raise the motion once we have heard testimony. If you believe that based on 23 DCMR 2000.1 that the testimony that was presented to the board doesn't give rise to the charge. So
on the front end, we're entitled to notice as to what it is that's charged and why it's being charged. And that's before we get to any evidence. We're entitled to have been able to prepare, which means that we should have been told what it is, what are the facts that gave rise to this alleged violation. And if you look at the notice, there are no facts given, nor are there any given in counsel's opening statement, other than, well, they pleaded twice before, so they must be guilty. And that's not enough. I don't even know how we defend this case.
Hold on. I'm not trying to cut you off, Mr. Silo. I mean, we're at a show cause hearing. Okay. The notice went out to notify the party. The show cause notice went out. We had a show cause status hearing. And of course, the parties can raise jurisdictional issues at any point. But I don't understand why is it that the licensee is saying at this juncture, they really have no idea why they're being charged. Why is it that motions weren't filed? Why wasn't a motion to dismiss filed previously? Why wasn't it even this issue? I mean, one of the things that I asked for at all show cause hearing status, I've said, are there any preliminary issues? I mean, this is something that could have been raised earlier for us to address it, and a motion could be filed by either side. A motion could be filed by the licensee, and we would have a response from the government. So we're here at a show cause hearing. The government needs to. The burden is on the government. They will call their witness. We will listen to the evidence presented by the government. Once the government has presented its case, if you want to raise your motion, you can raise your motion. The board will make a determination at that juncture whether or not we believe that a directed verdict, if that's what you call, should be issued, or whether or not we will allow you to present your case. And even let me say it this way. I mean, it's unlikely that the board will make a ruling on your oral motion. It's more likely that we will have the licensee, the government present its facts, you present your facts, and the board then will make a determination whether or not the government has met its burden. So that's where I prefer we move.
Mr. Chair, I would object to that because it seems to me in any proceeding such as this, the government has an obligation to meet its burden. And if at the conclusion of its case, it hasn't met its burden, then the board's got an obligation to rule on that. I mean, and if they have not presented sufficient facts to make out a violation, I hope that the board would fulfill its responsibility and dismiss the charge at that point.
All right, Mr. Klein, I stand corrected. It's premature at this junction for you to raise your motion.
Understood.
Let the government present its case, and you can, if you can renew your motion at that time, sir.
Thank you, Mr. Chair.
All right, thank you. Do you have a witness you wish to call, sir?
Yes, district calls Jeremy Zollicoffer.
Mr. Zollicoffer. Good afternoon, sir. Can you spell and state your name for the record?
Yes, my name is Jeremy Zollicoffer. It's spelled JeremyZollarCoffer.
Can you raise your right hand?
What?
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
You're a witness.
Thank you, Mr. Chair. Mr. Zollicoffer, what is your current position?
Investigator for ABCA.
And can you tell us briefly what the role of an investigator for ABCA is?
I conduct inspections and investigations to licensed ABCA establishments within the District of Columbia.
And did you have cause to conduct an investigation on Flash Catering on October 21st, 2022?
Yes, I was assisting another investigator in some alleged charges of caterer misuse on New York Ave.
And was that other investigator, Investigator Puente?
Yes, it was.
And you and Investigator Puente prepared a investigative report as a result of that investigation, correct?
That's correct.
Right. At this time, I request permission to share my screen.
Mr. Arena, can you please allow Mr. Cello to share screen?
Access has been elevated.
I'm showing what has been marked as Government Exhibit 1, which has already been admitted into evidence. Do you recognize this document?
I do.
And is this the investigative report we were just discussing?
That's correct. Yep.
And is this a true and accurate copy of the investigative report that was prepared after your investigation with Investigator Puente?
Yes.
Now, during this investigation, did you conduct an examination of the warehouse?
I did. Yes. While I was there, when I showed up the night of.
What did you observe?
I observed a large event going on in a warehouse, at 2101 New York Avenue. Appeared to have a nightclub atmosphere, and had several bars, had a stage, and quite a few people in it.
Was there a disc jockey?
Yes, there was.
And were people dancing?
Yes, they were.
Would you classify the operation as a nightclub?
Yes, it appeared to be.
Objection calls for a legal conclusion.
Mr. Cello?
Well, twofold. Number one, it's already been admitted into evidence. This is concluded in the investigative report. And number two, it's a categorization of the ABCA code, which an investigator is more than capable of making a determination. It's part of his job to do so.
Okay, fine, I'll cross them on it.
All right. All right, sir, you're withdrawing your objection?
Yes, I'll withdraw it. Fine.
Okay, go ahead.
So based on the music, the dancing, the time of night, the multiple bars, and the nature of the event, you were able to classify it as a nightclub?
It appears to be a nightclub. It was a very large event held in a warehouse that had a nightclub feeling to it. It had a live DJ, disc jockey. There were other things going on, but it was a large space with a large amount of people that came across as being a nightclub environment.
And they advertise themselves as such online, correct?
Yes, I believe so.
And they had multiple shows per weekend, every single week, right?
As far as I can remember, yeah, they were offering several events throughout the week. I want to say between 3 and 4.
Okay.
If I remember correctly.
And some weekends, according to the investigation that you and Investigator Puente had, some weekends they had multiple events per day, correct?
Objection, leading the witness all over the place.
Rephrase the question, sir.
I'll rephrase. What did you find with Investigator Puente about their advertising on their shows?
Not really sure. I know that there was some bottle service advertisements for different sections and bottle deals, which is common in the nightclub
Okay.
classification. But I'm not sure if it was on any kind of Eventbrite categorizing it as a nightclub. I'm not familiar.
Okay.
To be honest with you.
Now, ABCA has a nightclub license, correct?
That's correct.
And ABCA has a caterer's license.
That's right.
Are there differences between the two licenses?
Yes.
Do nightclubs have to have security plans?
They do.
What type of things would be typical for a nightclub security plan?
Objection is to relevance. We are headlong off of this legal conclusion that this is somehow a nightclub. I think the board is aware and has ruled many, many times that there is no formal definition of nightclub under the law other than the one contained in the ABC regulations or the ABC statute. And that definition is if you are licensed as a nightclub. As the board knows, we have taverns that engage in activity that can be concluded as nightclub activity in the vernacular. We have restaurants that do that. To now go off on a line of questioning that somehow this is improper because that's what's required of nightclub licensees is inappropriate.
I'll get to those other establishments, don't you worry. I asked for some leeway here. The entire purpose of this charge is operating beyond the scope of a caterer's license. So drawing the distinction.
Then let's deal with 2000.1, Mr. Chair, because that is what the charge is.
All right. I'm going to overrule the objection at this juncture. So I think part of what if I'm going to overrule the objection at this juncture. Let's move on.
I'll repeat the question. What types of things would typically be in a nightclub security plan?
Objection, it's irrelevant. This is not, they're not licensed as a nightclub. It's not relevant.
They are licensed as a caterer. They are charged with operating beyond the scope of a caterer's license.
Then ask them what's required in a caterer's security plan. Not licensed as a nightclub.
I'm overruling the objection. I'm giving the government some leeway to ask some questions. So let's move on.
I'll repeat the question again. What sorts of things are typical of a nightclub security license, a security plan?
I guess I would start by saying having sufficient security officers, a response to notify emergency personnel in the event of an emergency, things along those lines.
What about things like security cameras, having security training, anything like that?
That's all correct as well.
Now, as opposing counsel just pointed out, other establishments can operate in a similar manner. Restaurants, taverns, bars, all of those can obtain dancing endorsements, can obtain live entertainment endorsements, and they can have those type of operations, correct?
That's correct.
But a caterer's license can't get a dancing or live entertainment endorsement, can it?
No. Objection. It calls for a legal conclusion. There's no requirement that they obtain one. We're talking about law here.
It does not call for a legal conclusion. It's a question of very yes or no, up or down question in the statute. The ABCA code explicitly lists the type of licenses that can receive a dancing or live entertainment endorsement. Caterer's license is not on that list.
And there's no prohibition. All right, well, fine, I'll deal with it on cross.
I'll overrule the objection. Let's move on.
And caterer's licenses are not required to have security plans, are they?
I believe they are.
Okay. Now, you and Investigator Puente advised Mr. Issa, who's here as a witness today, that it was a violation to operate an establishment in this manner under a caterer's license, correct?
Investigator Puente advised, I believe. Yes.
And he advised that Mr. Issa was still operating off a caterer's license. That's the language I see in this report, is it not?
That's correct.
So I'd like to talk about that still in that sentence. Investigator Puente had advised Mr. Issa and Mr. Magadi on previous visits, did he not?
I believe that's true. Yes, he did. In the previous cases.
And specifically on February 12th, 2022 and February 26th, 2022. Did Investigator Puente advise them that their manner of operation was beyond the scope of their caterer's license?
Objection as to relevant. The conclusion is that it's beyond the scope of if it's their catering license. First of all, is a legal conclusion. Second of all, what he told them previously is irrelevant. We're here on this case, and whether on this date, under the facts of this report, the licensee is in violation, not what happened previously.
Mr. Chair, it's extremely relevant to the penalty phase of this matter. The fact that they had been advised multiple times that operating their nightclub in this manner in a continual fashion is beyond the scope of a caterer's license goes to their knowledge and intentionality and is absolutely relevant for potential penalty in this case.
Repeat penalties are dealt with in the schedule as a matter of law.
And whether or not this is an aggravating factor is a relevant conclusion for where in the schedule the penalty would fall.
All right, I'm overruling the objection.
I don't recall, Investigator Zollicoffer, if you had an opportunity to answer, but specifically on February 12th, 2022 and February 26th, 2022, did Investigator Puente advise Mr. Issa and Mr. Magadi that their manner of operating this establishment was beyond the scope of their caterer's license?
Yes. He did advise them in the previous pass about circumventing the system on trying to get a license and using the caterer over and over and over and over again. I believe him explaining to him, saying that you're operating outside the scope of a caterer's license for the previous 2 violations.
Now, how did Mr. Issa respond when so advised?
I believe I recall him with the understanding that he was just trying to get through, knowing that he had dates already booked out and that he was willing to accept whatever was coming, but his main goal was to transition to another place down Ivy City. But until then, he's going to keep on going until I think December of that year. So his intentions were to regardless that's the point that was
And specifically, in this report, he advised Mr. Puente that he needed to make money and still had to book talent to stay relevant in the industry, and that he intends to keep operating until the end of December. Those were the quotes.
Jackson leading the witness.
That's accurate.
Hold on,
that is
Mr. Zolikoffer, hold on, please.
That wasn't,
I'm sorry, go ahead. Yes, sir, go ahead.
that wasn't actually a leading question. I was asking if I'm reading the report correctly, which calls for a yes or no answer. It wasn't suggesting an answer. So that's not a leading question.
I think you didn't ask him if that was what was in the report, and certainly we can all read the report. I know all the board members are competent to read the report, as am I and my client. So I don't really understand the purpose of the question, and I don't believe that was the question.
Respectfully, the question was, are these the quotes from the report? And secondly, the reason for the question was to highlight these specific quotes, just to make sure that everyone is aware of what is contained within the report, which is already in evidence.
All right. Is there a question left for us to move on?
The question is, are those the quotes from the report?
They are.
Now, you mentioned the advertising as an event space and bottle service. Those were exhibits 14 and 15, correct?
That's correct, yes.
Okay. Scrolling through to exhibit 14, can you please describe what exhibit 14 is an advertisement for?
Is that the are we still on the bottle service exhibit, or I'm looking at something different?
This is
Or
exhibit
just a debate about
page 20.
Objection. Presumably the document speaks for itself unless he's got some independent knowledge as to what it is.
So what is it, the document what is the document we're looking at? What's on my screen? I don't know. What is it? I don't know what it is. So
this was identified as advertisement for the facility in the investigative report.
I believe this is the website that was referred to on where he was hosting the parties.
There's an objection pending, Mr. Chair.
Hold on. All right. What was the objection, Mr. Klein?
I forgot now. My objection was that he was asked, what this meant, and my objection was the document speaks for itself.
I don't know what the document is, though. So I don't know. You're saying the document speaks for itself. I don't know what the document is. So I want to.
Maybe he needs to be asked to identify it first. Maybe that's where we are, or should be.
Yes, I want the witness to identify what is the document that we're looking at.
That was my question, Mr. Chair.
Well,
can the witness identify the document?
Yes, sir. So the Warehouse 2101 is, I believe, the website that they use to advertise for their events, that offer bottles, the menu, etc., a little bit of back information of the space that they're occupying.
And you looked at their website as part of the investigation?
I personally didn't look too far into the website. I played assisting role on gathering some of this information, but I believe this is the site that I've came across in the past.
And did, under the events tab, did they list a number of events?
I'm not sure. Number of events to come,
Yes.
or the number of events that I believe they did have a calendar on events upcoming.
Okay, thank you. And as part of your investigation, did you and Investigator Puente look into their past history, their investigative history?
Yes.
And looking at pages 3 and 4 of your report, or I'm sorry, 2 and 3 of your report, there are 2 charges that involved operating beyond the scope of their caterer's license from 2/12/22 and 2/26/22. Is that correct?
That's what I see, yes.
And from charge 1 in each of those cases, well, first, how did these cases resolve?
Some of the charges were paid, fines paid, and some of them were dismissed in warnings for the
And more
previous ones,
generally,
but I believe that a charge.
More generally, were these
Charge
cases
one.
resolved through an OIC?
If you know.
Yes,
Was that an
I
objection,
believe
Mr.
so.
Klein?
Yeah, they.
No, it's fine.
Please
I
repeat
believe they did settle an OIC with board orders. Yes.
Thank you.
With-
And specifically to charge 1 in these 2 cases, how was the charge of operating beyond the scope of their caterer's license resolved?
Mr. Chairman, I'm going to object. This calls for legal conclusions. It's all set forth in the report. It's all set forth in the board's official records. He's not the best witness to testify as to how these were resolved. I think we can all see for ourselves.
I'll sustain the objection in this case. Let's move on.
In that case, Mr. Chair, I renew my preliminary matter motion for the board to take judicial notice of board order 22-663 and 22-637. Or I'm sorry, no, just 22-663 in both cases, as it was a joint OIC. And I ask that board order 22-663 be incorporated into the record.
What case is that, Mr.?
Board order 22-663 involving both case 22-251-0002 and 22-CMP-00018.
Okay. That's fine. The board will take judicial notice of its orders. All right, that's fine.
Mr. Chairman, I don't believe that both of those cases are referenced in that order.
I'm looking at the case history, and I don't have the order, but I'm looking at the case history, and I see case 22 CMP 00018 and there's another case number 22-251-0002. So those are cases that are referenced on the investigative history of the case.
I would ask the board to look at its order.
And I have pulled up the order on the shared screen. It does reference indeed both cases. It is as identified 22-663, order approving the offer and compromise. And the offer and
Going a little fast. Let's look at the
referred to
offer and compromise.
Okay. You don't have these documents in front of you, Mr. Klein?
I do.
Okay.
I want the board to have them in front of them now.
All right.
So if you will see, it references, we can stop moving, the offer and compromise for board approval.
Yes.
Scroll down, please. References 22, we went past it, 22-251002. I don't see any reference to the other case.
Well, I do believe this one was amended. I apologize. There was an amendment because of that typographical error. And the board order itself does explicitly reference up here. Here's the amendment. The board notes that a typo on the second page refers to 22251-0002, which is incorrect. The board modifies page 2 to read 22 CMP 00018.
Okay. No objection.
All right. So let's move on.
Investigator Zollicoffer, is it your understanding that Flash Catering had been operating with this establishment in this manner since at least February of 2022 and intended to continue its operations through December of 2022?
Objection. Let's talk about specific facts in terms of what his understanding is, and upon that, what understanding might be based.
I don't.
It's a leading question.
Mr. Chair, the question asked, based on his investigation, was it his understanding that Flash Catering had operated in this manner since at least February of 2022 and expected or intended to continue operating, that was the word I used, until December of 2022?
Can you answer that question, Mr. Zollicoffer?
I believe that is true. They were consistently using Flash Catering to use these events on a consistent basis for that. I believe that time frame.
No further questions at this time.
Thank you. Cross.
Sure. Good afternoon, investigator.
Good afternoon.
So you concluded that this was a nightclub operation, is that right?
No, I didn't conclude that it's a nightclub. It appears to be a nightclub. It operated on every 3 or 4, however many times a week, and it appeared to be a nightclub environment.
Okay, but you cited certain activity that that led you to believe that, right?
From what I've seen when I visited the establishment, that's what I'm going off of. Yeah.
All right. And what you saw was you saw people dancing, correct?
That's right.
You saw several bars, correct?
That's
You
correct.
saw a DJ, correct?
Right.
And those are the things that led you to believe that it was a nightclub type operation, right?
Well, it's a monster space with, probably thousands of people in it. Like, we're not talking about a little place. Could have it been a large festival event, like that, but we're talking a massive amount of people.
So along with the 3 factors I cited, then in addition, it would be the size of the place.
Objection to the characterization. Investigator Zollicoffer also identified the number of events in continuing operation, more than 3
Mr.
factors.
Chairman, if I may, this is cross-examination. Mr. Sello can certainly take the stand and testify if that's what he wants to do. But right now, I'm cross-examining his witness.
And I've objected to you categorizing it as the 3 things that you identified. The only other thing.
Mr. Chair, this is cross. Are you kidding?
Mr. Klein, Mr. Seller, I'm overruling the objection. Again, this is cross. Ask your question, Mr. Klein.
Okay, so the things that led you to believe that this was, in terms of activity that you observed on the premises, let's confine it to that. The activity that you observed on the premises that led you to believe that this was a nightclub type operation was you saw a DJ, you saw people dancing, and you saw several bars, correct?
That's correct. I mean, he also, I forget his name here. East Fay was basically explaining to me that he hires artists to come in and perform, and do things like that.
Okay, so in addition to that, there might have been in lieu of a DJ, there might be live entertainment, correct?
Oh, they were definitely booked out entertainers.
I'm talking about what you observed and what you experienced, which led you to conclude that this was nightclub activity.
Objection, badgering the witness. Allow him to answer the specific question that is asked without interrupting, please.
All right, gentlemen, it's cross-examination. Mr. Klein, please ask your question again, sir.
Yeah, so my question is, you observed, I'm talking about the activity that you observed. It was dancing, several bars, and music. It was DJ, although your understanding is, and sometimes it might have been live music, right?
Yeah, if that was the sticking point that the promoter was basically explaining on why he kept on rolling, was the
Okay,
fact that
but
he
that's
has
not my
these
question.
artists.
My question to you is your conclusion, as you said, it's you concluded that it was a nightclub, that it was a nightclub. You were asked that, and you said yes. So I'm trying to get to what it
Yes.
is that you observed. We've isolated these three factors. You added a fourth. You think you said the size of the venue. That was what led you to that conclusion, right?
Yes, it appears to be a
Okay.
nightclub.
Okay. How many weddings have you been to?
None. Maybe a couple.
Couple. Was there alcohol served at those weddings?
Objection. Relevance.
Completely relevant.
I'm going to overrule the objection. I'm trying to figure out where we're going. So I'm overruling the objection because I need us to get to the point of this case.
At the
Yeah,
weddings that you went to,
Yeah,
was
right.
there alcohol served?
Yeah, one of them was, yeah.
Okay. And are you aware that alcohol is frequently served at weddings?
Objection. Relevance. The investigator's personal experience with weddings has no relevance to the discussion we are having today.
I expanded it beyond his personal experience, and it is very relevant because he's concluded that this operation was a nightclub.
I'm overruling the objection. If the witness can answer the question, let him answer the question.
So you're aware that alcohol is served at weddings, right?
In not all cases. I've been to plenty of weddings that are dry, Mr. Klein. I mean, I'm not sure what you're getting at, because the cultural differences, people. So alcohol is not incidental. It's not part of weddings. No.
But it's not unusual for there to be for there to be alcohol at a wedding, is it?
It depends if that's your walk of life. I know many cultures that don't involve it.
All right. You went to one that had alcohol, correct?
I have been.
Okay. Were there bars?
Were they what?
Were there bars for people to order alcohol?
No. No, there was not a bar. No.
There was not a bar. Okay. And is there frequently music at weddings?
Yes.
And can that be sometimes live and sometimes a DJ?
Sure.
And do people sometimes dance at weddings?
All depends. Most likely.
Most likely. And when we think of catered events, a lot of weddings are catered, aren't they?
Are you saying this is a wedding?
I'm not saying anything. I'm just asking you a question.
Mr. Solokapa, your job is to answer the question, not to ask the question. Right. If you can answer the question, if you can't, right.
There was just a lot of reference to weddings. I'm not sure, but so to answer your question, what was the last one you asked?
Last one I asked is many weddings are catered, aren't they?
For the most part, that is correct. Yeah. Well.
So there certainly could be a catered event where there would be a DJ or live music, people dancing, bars set up for people to order alcohol. And the only difference between what you saw and what might be permissible is there might be a woman or a man, depending, in a white dress or a white outfit, and vows are exchanged, right?
Objection, both to
No,
categorization and to relevance.
no.
Mr. Chair, it goes to the crux of the case. He's made a determination that this is somehow impermissible under the catering license because these activities were going on. So I'm asking him about another type of event, which I think we all know are frequently catered. And what's the difference? There's somebody in a white dress. That's what I'm trying to figure out.
All right.
Well,
I'm good on. Hold on, sir. I'm overruling the objection. Answer the question if you can, sir.
So I missed the last part of that question. I had an answer for you.
So I'll ask it
Can you
again.
repeat yeah.
You said you visited this event. You saw music. You saw people dancing. You saw several bars. You saw people consuming alcohol. I think we've established that you might see the same things at a catered wedding. And my question to you is, the only difference between those events is that we have two people who exchanged vows and committed themselves to each other? Is that the only difference between what you saw, which you seem to think is impermissible, and a wedding that might be catered? Which would you think a wedding being catered is permissible? Let's establish that first.
Well, no, I think it's important to note that this establishment has been reported from the community.
That's not my question
about
to
having
you,
large
investigator.
large
Investigator,
events.
that's not my
But to
question.
answer you,
Hold on,
Mr.
Mr.
Strike,
Klein,
the
to
response
answer,
is unresponsive.
hold on,
can you give
Mr.
me a chance to answer?
Hold on, Mr. Zollicoffer. All right.
Chairman Anderson, the investigator, the witness, has to be given the opportunity to answer. He was asked a trick question and he was answering with the best of his ability. He was asked a yes or no question, didn't have a yes or no answer.
I'm aware of that. That's why. All right. Mr. Klein, you need to give the witness an opportunity to ask a question, to answer the question that's been
He
asked.
attempts to answer the question that I asked. I will certainly do so.
Mr. Klein, you asked a question and the investigator is answering the question the way he receives it. He might not be answering the question the way you want him to answer it, but he's answering the question the way he believes this is the answer that's to the question that's been asked.
All right, let me ask the question again then, because maybe he didn't understand the question. The question I asked you is a simple yes or no question, and the question is a catered wedding event, a wedding event where a caterer provides alcohol and food, where there is dancing, music, bars, alcohol and food consumption. Is it your understanding that that is permissible under a catering license?
Yes, if it was a one-time event, not
Okay.
over and over again.
Okay. And if there was a particular location, and I can think of many, where there were weddings every weekend under a catering license, um, and there was a catering license and it was a wedding and it had the attributes that we've discussed, is that permissible under a catering license?
No, I don't believe so.
Are you aware of the provisions in the ABC law concerning the protest of a catered event site?
No, not necessarily. No, I don't believe so.
All right, fair enough. All right, now the other two cases that you've been asked extensively about that resulted in the OIC, were you involved in those?
No, I didn't write those. I wasn't involved. I might have been present on I'd have to look over the hearing. I'd have to look over the case report,
Mr.
specifically to see
Zolikoff,
whether or not I was present.
Mr. Zolikofer, a question's been asked.
Yeah.
Yes or no? If you don't know, I don't know. If you're not being asked to speculate, sir. Answer the question to the best of your knowledge, sir.
I don't know. I'm not sure. I believe I was aware or might have been present for one of them, but I'm not 100% sure. I just remember I remember these.
But you're aware what went on because you were asked and answered questions about them, right?
About the previous charges?
Yeah. Uh-huh.
Yes. I am aware. I am aware of the track here.
And didn't the previous cases involve concern about a certificate of occupancy and whether there was an appropriate certificate of occupancy for the number of people that were there? Isn't it true that both of those cases involve that?
Objection. The relevance.
Seriously.
The relevance.
You opened the door wide open. What are we talking about?
The relevance of charges in addition to the charge at issue today is not relevant as it relates to those other matters.
Mr. Chair, Mr. Solar wants to have it both ways.
I'm overruling the objection. If the witness can answer the question, he can. If not, let's move on. Are you able to answer the question, Mr. Zolikofer?
Sure about the specifics on the C of O on the previous cases.
So what do you know about the previous cases then?
I just know from the history, and I'd have to look at the specific case to see whether or not I was involved, but I'm just looking at the history showing that there's been a pattern of operating the caterer's license outside the scope of a caterer's license that's been charged two times prior to this charge for the same location, same situation.
All right, you were asked a lot about a security plan and whether one's required or not required. You don't have any idea what provisions that this establishment had for security, do you?
Flash catering?
I'm sorry? This location, this event, you don't have any idea what provisions they had for security, do you?
No, I don't believe it was required for the caterer's license. They didn't mention anything that I know of.
Okay, so you agree that a security plan is not required for a catering license?
Yeah, that's correct. It's not required.
All right. And you agree that for the weddings that we talked about, no security plan would be required, correct?
That's correct. That's correct.
And you agree that the weddings that we talked about, there would be no entertainment endorsement required under a caterer's license, would there be?
No, the caterers is the ultimate loophole.
The ultimate loophole. So loophole meaning that it's perfectly legal, isn't it?
Your screen is frozen. I didn't hear you.
I said so. So when you say it's a loophole, you admit that it's legal, but maybe some people don't like the fact that it's legal, right?
Well, the caterer's license doesn't require the security plan. They don't require it, so it's more so it's using it for special events and just not on a continuous basis at the same club every week, several times a week.
Okay. How long have you been an investigator?
4 years.
All right. And how long have you been in the District of Columbia?
My living, I'm familiar with the area 20 years, full-time, probably 5 years.
Okay. What did you do before you were an investigator?
Objection, relevance.
I'm going to overrule the objection.
Work law enforcement. Department of Corrections.
Okay. All right, I don't have any further questions of the witness at this time. Thank you.
Any questions by any board members? Go ahead, Mr. Short.
Thank you, Mr. Chair. Investigator Zollikofer, how are you this afternoon?
Mr. Short, I'm doing well, thank you.
Okay. Now, on the night that you investigated and wrote violations for 2101 New York Avenue Northeast, was there a wedding going on?
No, there was no wedding.
What time of day or night was it?
Approximately 11:15 p.m. All these events happen at night.
Okay. And to your knowledge, as an investigator for ABCA, has any other caterer been charged with operating as a nightclub in Washington, D.C.?
Not that I know of, off the top of my head, Mr. Short. Not to my knowledge, Mr. Short.
Can you tell me the normal operation of a catering or caterer's license? What are their normal operating procedures?
Well, I understand caterer's license to be used as to facilitate an event in the event that they have a space, public space, private space, and they want to throw on an event and they want to sell alcohol in the district, so they can use a caterer's license to facilitate that, the food portion of it, and then the alcohol can be incidental.
Are permits required whenever caterers do that for the event?
Yes.
Was there ever anything filed in the office of ABCA, to your knowledge, for the use of 2101 New York Avenue Northeast for any catered events, to your knowledge?
Not to my knowledge.
So anyone listening to your testimony could say, it's very unusual for a caterer not to have a permit, and illegal for a caterer not to come and file and pay a permit fee. Is that correct?
Mr. Chairman, I object. That's wrong. It calls for a conclusion of law, and it's wrong as a matter of law. There is no such requirement.
Can Mrs. Zollikofer answer the question, Mr. Chair?
I have no idea how I got muted. All right. I myself I'm not aware, but if the witness if he knows and can answer, then he go ahead.
Sorry, Mr. Short, can you repeat that again?
Okay. It seems to always happen when we get an interesting question that I have to repeat it, and I think it's distracting. However, I will try to reconstruct my question as best I possibly can.
Okay.
The question I asked and wanted an answer to was, are caterer or catering licenses in the District of Columbia normally have to pay a fee and get it to operate for a catering event that they are using their license on?
I don't believe so. I believe that they have the caterer's license that they keep in compliance, and then they can use their license for certain events. I don't think it has to be pre-approved for them to use their caterer's license prior to an event.
To your knowledge, Mr. Zollikofer, have you ever or know of any investigator who's been sent out to investigate a licensed caterer event?
Sure. We've been sent out to look into certain catered events. in the city, yes, that we know that are operating the caterer's license.
On February, Mr. Lewis again, on Friday, October the 21st of 2022, was there any notice or any application made for an event to be catered at 2101 New York Avenue Northeast? That's yes or no?
No.
Okay, now what I'd really like to know is, and it's been brought up several times in this case, that this is not the first time that the 2101 New York Avenue Northeast has been cited and paid fines. Is that correct?
That's correct.
What were those fines for, sir?
For case 22-251-0002 is operating beyond the scope of a caterer's license. Primary charge. Sold, delivered, and served alcohol beverage without offering sufficient food was charge 2. Received complaints from the public concerning disruptive activity, charge 3. Operated without obtaining an updated certificate of occupancy. Operated in violation of multiple fire codes. The board referred to OAG for show cause, and the board accepted an OIC in lieu of the hearing for charge $1,000, charge $2,000, charge 3 was dismissed, charge 4 was a warning, charge 5 was dismissed. So there were cases similar to this that were charged, and there was an offer in compromise for the 2 of them, I believe.
You mentioned fire code violations. Were there any fire regulations found that night? And if so, did the fire department issue any violation?
I don't believe so, sir. Not on that particular night.
Has the fire department, to your knowledge, ever issued a violation to 2101 New York Avenue Northeast?
I'll
respectfully
object to the relevance as it relates to the charge at issue today.
Thank you. I understand. Well, I guess my last question would be, Mr. Zollikofer, and I think this is permissible. What is the total number of violations that money has been paid by this caterer or catering license?
Objection. Calls for a legal conclusion. I'm not sure I could even answer that.
I asked for the number of dollars that have been paid for fines. That's not asking for a conclusion. That's asking for a fact that's on the reports that have been filed with ABCA.
How does this investigator know what's been paid?
It's in the history, Mr. Attorney, sir, Mr. Klein. It's in the history, and the history is truthful knowledge of this caterer's experiences, both legal and illegal, for ABCA. And as so being in the history, I would like to ask again if Investigator Zollikofer can give us the number of fines that have been charged and the amount of dollars on public record that have already been admitted for this hearing. If you can answer that, Mr. Zollikofer, I would appreciate it.
Okay, so I believe there's $4,000 that's been paid in the last 2 charges that's been paid in full for these $4,000. I might have missed you breaking up on it. Might have missed the end part of that, Mr. Short, but there's been four different violations. They've all been paid $4,000 in total.
And were they paid $1,000 each?
Yes, charge 1, 1,000, charge 2, 1,000. That was for case ending in 00018, case ending in 00002. Charge 1 was $1,000. Charge 2 was also $1,000. Total of $4,000 paid.
So Ed, is it true that the night you were there on Friday, October the 21st, 2022, they had already been told that they could not keep operating like that illegally. Is that true or false? Yes or no?
Objection as
That's
to
true.
illegally? That's for the full board to make a determination as to what's illegal.
Mr. Klein, I do believe when you pay $4,000 over a certain period of time for the same types of violations, that's history is part of the record, and that they didn't pay the money and keep operating illegally. It was illegal for them to do that after they paid the fine, and they were told the reason for that was they could not operate safely or with a license in that location at that address. They had been informed.
Your understanding of what is an offer and compromise is very different than mine. I'll just say that.
May I
Let's
respond to
let's
the
let's
objection, Mr. Chair?
let's move on. Let's move on. Do you have another question, Mr. Short?
Mr. Zollikofer, I'd like to thank you for your excellent report and for doing your duty as you are paid by the District of Columbia. And this board supports everybody who works for ABCA and for the District of Columbia. Thank you for your service. That's all I have, Mr. Chair.
Yes, sir.
Any other questions by any other board members? Mr. Zollikofer, why did an ABCA investigator show up at the establishment this night?
Time to arrive?
No, sir. Why was an investigator at this location?
I believe we got a hotline phone call about large crowds kind of spilling into the street, New York Ave, a warehouse that appeared to be throwing these large parties. I think it was a call. It was a call from the public to respond over there for large crowds in the street.
So when the investigator, so were you one of the investigators who showed up?
Yes, on October 21st. Yes, I was.
So what did you see on October 21st when you appeared at the location?
I remember arriving on the at the location, seeing large crowds of people. We entered. We met with the ABC manager. There was several different shops in there selling jewelry. They had some food for sale. I believe it was pizza to the side. There was an entrance where they were charging, or they might already had prepaid tickets for the event. And then as you moved further into the back of the facility, it kind of just opened up into like a massive open warehouse space, which had the majority of the people back there with stages that were assembled, and yeah, kind of like a concert environment.
Why did you say it like a concert environment? Why did you say that? Why did you start it?
It was a very large space. You know, it's one of the larger spaces that I've been to in the district. It had a big stage, those people performing, you know, just like concert type, you know, people blowing smoke and different types of lighting, and just there's a lot of people, loud music, and the way that the stage was set up, it appeared to be, you know, like a nightclub type of concert going on.
So are you stating that based on your experience as an investigator that this appeared to be a nightclub? Is that what you're testifying to, sir?
Yes.
All right. Any other questions by any of the board members? Mr. Klein, any recross?
Yes. Investigator, you said that the two previous charges involved activity similar to what you saw here. Is that correct?
Yes, that's correct.
Okay. Now, in looking at the investigative history, in CMP, in 22-CMP 00018, charge 1 said that that the licensee sold, delivered, and served alcoholic beverages without offering sufficient food. Isn't that what that says?
I believe operated beyond the scope of caterer's license, right?
Well, look at, okay, it says operated beyond the scope of its catering license. And then what does it say right after that?
Objection as to the categorization. Opposing counsel is reading charge 2, which is a different charge and which is not.
I stand corrected. Charge 2 then.
Well, in that case, I object to relevance. The fact
Seriously?
that they were at that time not selling sufficient food is not relevant to whether or not they were operating beyond the scope of their caterer's license in this instance.
It's relevant when the suggestion has been made that this applicant is on notice because of the prior charges, and the witness is asked whether the previous charges related to and I'm paraphrasing, related to facts similar before the board in this case. And an examination of the history reflects that that's just simply untrue.
All right. I'm over. Go ahead, Mr. Sila.
Opposing counsel is suggesting that because there were additional violations, we should not look at operating beyond the scope of the caterer's license. If they were operating beyond the scope of the caterer's license because they sold, delivered, and served alcoholic beverage without offering sufficient food, that would have been a single charge. It's 2 separate, distinct charges. And the fact that they were committing more violations in the past than they are now does not in any way excuse the fact that they're still committing some of the same violations.
Mr. Chairman, here's my problem. My problem is in the previous cases, there were specific charges related to operating beyond the scope of the catering license that are specifically referenced in 23 CMR 2000.1, specifically the reference to sufficient food. So at least we're on notice as to what it is that the applicant is charged with doing or not doing. In this case, we have operated beyond the scope of its catering license, referencing 23 GCMR 2000.1, and we have no idea other than, well, gee, it looks like a nightclub. We think it's a nightclub. You can't do that. And then further, it goes on to say that it operated without following construction codes by not obtaining an updated certificate of occupancy. And in this case, there's a certificate of occupancy attached. So for me not to be able to question the witness as to why it is he concluded that they're similar is beyond me. I don't understand.
All right. This is recross. Questions were asked by board, and I've given the attorney an opportunity to recross. And so that's where we are. These are issues that were raised by a board member. So let's move on from here.
So is he to answer the question or not?
Yes, unclear. He should answer the question if he can answer the question.
All right, I'll try to move it along. So, investigator, isn't it true that as reflected in your investigative history, with respect to 22 CMP 00018 and case number 22-251-0002, in those 2 cases, you had, number 1, charges of selling, delivering, and alcohol without offering sufficient food. Isn't that correct?
That is one of the charges, right? Charge 2, right?
Okay, and that wasn't present in this case. That's before the board today, right?
That particular wasn't present in the charges. No,
yeah, I mean that's not. You're not alleging that they weren't selling food, are you?
No.
Okay, and then there are also concerns in both cases related to a certificate of occupancy, correct?
That's correct.
And in this case, there is a certificate of occupancy that's appropriate because it's indeed attached to your report, correct?
Correct.
So when you say that the facts in the previous two cases were similar to the facts here, that's not entirely correct, is it?
No, it is. It is similar. We're talking about a consistent. You're talking about two different charges that were prior to this for the same reason. For the same reason,
All right.
operating beyond the scope of a caterer's license.
All right. Let me ask you this. And you were asked whether there was a wedding going on. Is there any requirement in 23 DCMR 2000.1 that in connection with a catered event, a wedding be involved?
Objection, relevance, and
It's following up on the question asked by the board member.
Let the witness answer the question if he can, so I'll overrule the objection.
Ask the question again, Mr. Klein.
Is there any requirement in 23 DCMR 2000.1 that a catered event involve a wedding?
Specifically, no. Caterer, no.
It could be all kinds of events, right?
Right, that's right.
Okay. So as an investigator, your job is to investigate, and you've got to look at the code and regulations and make a determination based upon the code and regulations what you believe a violation might be, correct?
Right.
All right. So looking at 23 DCMR 2000.1, and if you don't have it, we can pull it up for you. What is it specifically in 23 DCMR 2000.1, given your experience as an investigator, you contend that this licensee violated?
I don't believe that was one of the violating charges. Is 2000.1 or whatever you refer to? Is that one of the charges? I thought it was under a
that is the charge.
25-113.
All right. No further questions.
Mr. Silo.
Investigator Zollicoffer. When you were identifying the factors that led to the violation with counsel for the licensee, there were several things listed, including several bars, a DJ, dancing, the size of the space, live entertainment, and the continual operation with multiple events each weekend. Of those, I'd like to focus on the continual operation. Can you explain why that is a problem for a caterer?
Caterers are not meant to be used in that way on a consistent basis.
Hold on, Mr. Zollicoffer. What is your objection, Mr. Klein?
It goes beyond the scope of cross, and it calls for a legal conclusion. I don't, this isn't in the law. I don't know what we're talking about. Like, let's show me in the law where it says that this is a violation. That's been my objection throughout this. Where in the law is this a violation?
It absolutely does not go beyond the scope of cross. If the board will recall, I objected to the categorization of Attorney Klein that he excluded the continual operation of, with multiple events each weekend, which investigator Zollicoffer had testified to on cross. He excluded that when he was going over why is this a violation questions, and my objection was overruled with a specific proviso that I can inquire about it on redirect. So it's not beyond the scope. And secondly, I am not asking for the legal conclusion. I'm asking why that factor was relevant to Investigator Zollicoffer when he was describing the situation and the violation.
I'm overruling the objection.
So,
Go ahead.
Investigator Zollicoffer, to repeat the question, the continual operation with multiple events held each weekend, that factor that you identified, why was that a problem for you for a caterer?
It's my understanding that a caterer is not to be used that way. It's for special events, not to be consistently used for that purpose several times a week for what appears to be a nightclub. You know, like it just, from what I know, the caterers aren't supposed to be used for that same address, continuing events on a consistent basis that are already scheduled out 3-6 months in advance.
And is it your understanding that Flash Catering was organizing these events?
Yes.
And do caterers typically organize the entertainment and the live performances of events, or are they typically responsible for the food and incidental to the food, the alcohol?
Yeah, caterers, I believe, just responsible for the food and the alcohol, but they don't necessarily have to do anything.
As part of your investigation, did you look into the social media of Flash Catering?
I didn't personally.
Okay. And when you referred to continual operation, you said that there were, I believe you said 3 to 5 events per weekend. Is that an accurate accounting of your testimony?
Objection. Goes beyond the scope. Objection. Goes beyond the scope, and I got no opportunity to recross on this point.
I'm overruling the objection. Let the witness answer the question if he can.
Did you testify that it was 3 to 5 events per weekend? Was that the accurate number you had testified to?
Along those lines, I want to say, yeah, maybe 3 or 4 events I think that they had scheduled, definitely on Fridays and Saturdays, and I believe maybe once during the week.
Okay. And when you referred to continual operation, over the course of how many months were you referring to?
That I believe was several months. I'm not 100% sure on how many months. Maybe a year's time.
Okay. And just to hit on the wedding question once more, are weddings typically one-off events, or do the same 2 people continually get married 3 to 4 times a week for an entire year?
Yeah, I guess no, one particular time.
So this is a distinguishable manner of operation.
Yes.
And in the manner of operation that you observed, was this charge for the continual operation of a nightclub, or was it for any of the other things Attorney Klein asked you about as they relate to charge 2, 3, 4, 5 of the other cases in the investigative history?
Objection.
No, this.
Objection.
What's the nature of the objection, Mr. Klein?
We're beyond the scope. I mean, I don't like what?
Yeah, Attorney Klein extensively inquired as to charge 2. In that case, they were food. In this case, there's no food. Charge 3, there was fire code violation, complaints from the public. We went through.
Yeah, but those are actual violations under the code. I mean, we're just making it up.
And Attorney Klein is arguing that without those other charges, he can't possibly know why his client is operating beyond the scope of the caterer's license. My question is to point out that the basis for that charge in all three instances was their manner of operating a continuously running nightclub while using a caterer's license. And that is consistent throughout all three cases.
All right. I'm overruling the objection. Let the witness answer the question if he can. And I guess
I believe that is the ongoing, the basis of it all, right? They continually operating a nightclub on a caterer's license on a weekly basis.
Nothing further at this time.
Thank you. Do you have another witness, sir?
No, the district rests.
All right. All right. We're going to take a break. And when we come back, you can call. Do you have a witness you plan to call, Mr. Klein?
Yes, sir. I plan to move to dismiss.
All right. All right. It's 3:23. We'll be off the record until 3:35. So we're off the record until 3:35. All right. We're back on the record. Do you have a witness you wish to call, Mr. Klein?
I move to dismiss the single charge that has been made against the applicant and wish to be heard on argument. The government has not met its burden of proof, and I wish to argue why that is.
The board is not going to rule on your motion at this juncture, Mr. Klein. The board will reserve your motion. I'm not saying that we will not rule on your motion, but at this juncture, the board is not going to make a ruling. We're going to reserve making a decision on your motion. One of the things I stated before, I do not know why is it that the parties did not file motions. If you strongly believe that, based on the charging documents, you have had, and I'm just saying, in process-wise, that the parties could have filed motions that would have given the board an opportunity to look at the law and make a decision prior to the hearing. We have not filed the motions. I'm not comfortable making a decision at this juncture. I believe that you should present your case. The board, once we have consulted with, we'll listen to the presentation that was made by the government, look at the law by consulting with legal, and we'll make a decision whether or not we're going to dismiss the case based on the motion that was made. So at this juncture, if you want to rest or not present a case and make arguments, that is your option. But we're going to reserve making a decision on your motion at this juncture.
Okay. First, then I'll proceed with the case. First, I would ask that the board take administrative notice of an exhibit that was filed, which is from WJ, and I don't like submitting things from the press, but I think it's appropriate in this case. From WJLA TV website. It's a story dated December 14th, 2010. And we submitted as an exhibit timely. The title of it is How Grey Goose Mansion Became
Hold on 1 minute, please. Let him finish. I don't know what it is. You can't object at this moment, sir. Let me find out what it is that it's that's been asked to place in the record. Go ahead, Mr. Klein.
It's the title of it is How Grey Goose Mansion Became a Popular Night Spot Without Becoming a Nightclub. And in the story, there are statements from the then chair of the ABC board, Charles Brodsky, along with a spokesperson for ABRA by the name of Cynthia Sims. So we are asking the board to take administrative notice, along with anything in the board's records relating to the fact-finding concerning the Grey Goose Mansion, which is an operation back in 2010. Mr. Brodsky says,
Objection.
quote,
Hold on. Let me ask a question first.
Sure.
Was this document? I'm asking you, Mr. Seeler. Was this document provided 7 days prior to the hearing?
It was on an amended notice. I don't recall if the amendment was 6 or 7 days prior to the hearing, but they did file a timely exhibit notice, and this was an amendment within 24 hours, so we are not challenging the timeliness. However, before any of the quotes are read, I do have several objections to raise about the admissibility of this exhibit, and I wish to be heard on that.
But I don't know what the problem that I'm having at this juncture, I don't know what it is. So you're objecting.
But respectfully, Mr. Chair, it is not appropriate for the trier of fact to see this document. If I can just explain my position, please.
All right, go ahead, sir.
All right. The exhibit that is being sought to be introduced is an irrelevant and unreliable newspaper article, essentially. It's from ABC 7 News, concerning the board's determination of a fact-finding hearing in 2010, which contains multiple levels of unreliable and out-of-context statements from various, at the time, ABRA personnel. If Attorney Klein wants to argue about the precedent of this fact-finding hearing, then certainly he could cite to the case and argue the case. It is not, however, appropriate to, instead of citing to the case and the board's order, to cite to the opinion of a reporter who is interpreting the case for public consumption. Moreover, I would note that this was Attorney Klein's case. He has access to the order. He can cite to the order. He was the attorney in this case. And it is absolutely not appropriate to take specific quotes or comments out of context based on what the reporter thought would make a good story, and for this board to take judicial notice of that. The proper evidence, if it is deemed to be relevant at all, and I would argue that it is not because the case is quite distinguishable for the current case, but the proper evidence is this board's order from 2010, not a newspaper article interpreting the board's order. So I would argue that this is highly irrelevant, highly prejudicial, and unreliable, and this board should not take notice of it and should not admit a newspaper article into the record.
So Mr. Klein, why is it that you are submitting a newspaper article that and I don't know if that, because I have not seen it, that is interpreting what the board wrote in its order in 2010, or their version of what's written in the order?
I'm not. There is no order. It was a fact-finding hearing. There's no order. There is no order. The board held a fact-finding hearing, and that was the end of it. So there is no order. But what there are public statements quoted from the chair of the ABC board and from then ABRA's public spokesperson, which informs the public as to what the law is. Now, if Mr. Cello had some problem with that, then he certainly could call another witness and dispute that these are the quotes that were made by Mr. Brodsky or Miss Cynthia Sims. But in the absence of that, and and we'll get into it on closing, but I mean, we have serious due process concerns here where the public is entitled to know what the expectations are under the law. And when the chair of a board and the spokesperson for an agency says very clearly, which I'll read to you if I'm allowed, what the law is, then it seems to me that that informs the board as to whether this should be deemed a violation or not, simply based upon whether the public has been made aware in accordance with the requirements of the Fifth Amendment regarding due process, and is quoted by a case that we discuss probably every other week, although never by name, which is Papa Cristo versus City of Jacksonville, Supreme Court, and it deals with loitering and vagrancy. And it ruled those as unconstitutional because nobody knew what they were and they were applied inconsistently. And that's exactly what's going on here. And it will be shown if I'm allowed to submit what I've proffered.
If I may respond, Mr. Chair.
Yes, sir.
With my own proffer, the case in question is highly distinguishable from the current case. The case that from 2010 involves an establishment that was operating a arguably a nightclub style of service, but it was operating it from a venue that rented the venue out to a number of different parties. This was operating once a month, sometimes more, in distinct individual services with distinct individual agreements with the catering service. And the premises were rented out for weddings, they were rented out for things during the day, they were rented out for a hot yoga studio, they were rented out for all sorts of things at all sorts of times, which is a very different situation than Flash Catering operating this warehouse exclusively for a year and running events multiple times every single week. So it is not
Mr. Cello is stating facts that are not in evidence.
and is absolutely not relevant to the current proceeding.
I'm not. We're talking about a newspaper article. I mean, if we had maybe the transcript of the hearing, if we had.
Mr. Chairman, these are public statements made by the chair of the ABC board and by the spokesperson for the agency.
Mr. Klein, with all due respect, I'm currently the chair of the ABC board. I don't speak for the board. I mean, I speak for the board when there's a quorum. So I can only state that as a chair, I don't go to the newspaper. And I don't know what the board did in 2010, but in 2023, I do not talk to a newspaper reporter and say, I am here speaking for the board. I mean, if I was to talk to a newspaper reporter, I will say this is my personal opinion, but I can't, outside of a quorum, I cannot speak for the board. So
And Ms. Sims, the spokesperson for the agency, didn't speak for the agency either?
Ms. Sims is a spokesperson. Well, the problem that I'm having, we're talking about newspaper articles, sir.
Can I read the quotes so the board can make a determination as to whether they're relevant? I mean, that's normally what you would do.
You know, Mr. Klein, you're going to force me to make a decision that at this juncture. And so this is what I'm going to do, Mr. Klein. Okay. I'm going to consult our legal office. Okay.
Okay. Sure.
All right. As chairperson of the Alcohol Beverage and Cannabis Board for the District of Columbia, in accordance with DC Official Code Section 2575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 22 CMP 00084 Flash Catering, pursuant to DC Official Code Section 2575B4A of the Open Meetings Act. And all right. And well, and I said deliberating upon case number 22 CMP 00084 Flash Catering for the reasons cited in DC Official Code Section 2575B13 of the Open Meetings Act. Is there a second?
Short, I second.
Mr. Short, I second the motion. I would now take a roll call vote before it's now has been properly seconded. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. I hereby give notice we will take a brief recess. It's 3:53. We are off the record. We will be back once we're ready to be back. All right. So we're off the record. Thank you. We're back in the record. Mr. Klein.
Yes.
Mr. Grandis, I know you're here because I can look at you, so I need. All right. Mr. Philo, what was the purpose? You raised an objection. What was the nature of your objection?
My objection was multifold. First, that the proper evidence to put before the board would be a transcript of the hearing, or any orders that stem from the hearing. It is not the best evidence to put forth a newspaper article interpreting the hearing. Second, that it is irrelevant to these proceedings. And third, that the newspaper article is unreliable, contains out of context quotes, and therefore should be excluded on 3 separate bases.
Mr. Klein?
Yeah.
In response?
Yeah, on all points. First of all, the transcript was one thing, but these were public statements that were made, and were out there in the public sphere. In terms of their reliability, Mr. Seller's known about this for a week, and it was timely filed, just to be clear for the record. So he was certainly free to go get whatever rebuttal evidence that he wanted if he thinks it's unreliable. It is an out-of-court statement. They are hearsay. However, or they're not hearsay actually, because they're not offered for the truth of the matter asserted. So they're not even hearsay. Number one, and number two, I mean, the board can give them whatever weight they want to give them. In terms of their relevance, we have a due process issue here. And this licensee is told that it violated the law. And it's told it violated the law despite the fact that the chair of the ABC board, in a very similar setting, said exactly that it didn't violate the law. And the spokesperson for the agency said basically what the investigator said, that it's a loophole. And if it's a loophole, then, as I said to the investigator, then it's not illegal. And that's what these people say. So as a matter of due process, we think this is very relevant, because to suggest that, and we'll go through in closing 2000.1 and what it says and what it requires and how it's far afield of what we've talked about here. But this gives it some context, and the board can do with it what it will. But it would seem to us that quotes from the chair of the board, even though he doesn't speak for the entire board, and comments from the spokesperson for the agency are very relevant in terms of what should be expected from licensees.
May I respond?
Yes, sir.
First of all, if they're not offered for the truth of the matter asserted, then they're not going to be adding context to these proceedings. Secondly, that also calls into question their relevance. And thirdly, because the situation in the case 13 years ago was a fundamentally different set of facts than the current case, particularly as it relates to what investigator Zollicoffer testified was the primary issue in these charges being brought, the continual operation of a nightclub day in, day out for a year, that is a very different situation than what was occurring in 2010. And therefore, any of these quotes are not relevant because they are not addressing the same fact pattern.
It may or may not be different, and Mr. Sello can point out these differences. If I may tender the article, I think you'll see it's not really all that much different. And he can certainly argue how it's different, but that doesn't go to its admissibility. That goes to its value to the board. And to say, oh, it's completely different, I invite you to read the article and draw your own conclusions as to whether it's completely different. And am I suggesting that this is binding upon the board? No. But what I'm suggesting is notice was given by the agency, by the chair of the ABC board, as to what conduct was acceptable, and to now just turn that on its head and say, yeah, you know, who cares? I'm sorry. I mean, that's a violation of due process, and it raises the very issues that were at issue in Papa Cristo, which goes to due process in terms of, do we know what conduct is prohibited? Do we know what conduct is required? Or are we going to make it up as we get to each case? And if you read this article and go back and look at the transcript, which you're free to do, because it's part of your record, and I've asked that administrative notice be taken of it, you'll see it isn't all that different at all.
Relevance and prejudice go directly to admissibility. It's not a weight question. This is a question of admissibility.
Prejudice.
Fundamental facts at issue are different in this case and the case from 13 years ago. And quotes about a case that is not similar from 13 years ago are not relevant to these proceedings. They can only prejudice these proceedings that should not be admitted.
All right. Both parties have made great arguments. Again, we're talking about 13 years ago. We're talking about statements by the board chair 13 years ago, and statements by the spokesperson for the agency 13 years ago. And DC is a completely different city than it was 13 years ago. Maybe what was acceptable 13 years ago might not necessarily be acceptable now in 2023. With that said, this is an administrative hearing, so we do not necessarily go by the strict rules of evidence in administrative hearing. And so in this particular case, I'm going to make a motion that the board allow the document in, and that we will give it the weight that it's due. Is there a second?
Grandis will second.
Mr. Grandis a second. I'm going to take a roll call vote. Mr. Short. Mr. Cato. Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 4-0 to 1. I think 4-0 to 1 with Mr. Short voting present. All right, so we're going to allow the document in, but we'll give it the weight that it's due. One of the concerns that I have with this case, there are a lot of motions that are been made, and it would help the board if we had received, in a sense, the motion that you have raised earlier, Mr. Klein, if it was done in writing, so the board would have had an opportunity to review the law and make a decision earlier. And it's the same thing, Mr. Silo, in the sense that the document was provided 7 days within. You're not objecting to the timeliness of the document. Maybe if you did, maybe I would have ruled otherwise. Okay, so we will allow the document in and give it the weight that it's due.
Mr. Chair, with that, I'd like to read the quotes that are from Mr. Rodsky and Ms. Sims.
And you can do that, Mr. Klein, but as I'd stated before, as you know, the board operates 3 members as a quorum, and any statements that were made by any board member outside of a quorum cannot bind the board to say these are the position of the board. At least as currently as chair, that is my position. But yes, sir, go ahead and read.
I've already acknowledged that, Mr. Chair. I mean, I understand that, I've acknowledged that, and it goes to the issue of notice. more so than, what the board should decide in terms of what the common understanding was. So if I
Yes,
may,
sir.
quote, Mr. Brodsky, quote, "We think you did an end run and opened up a nightclub in a neighborhood that doesn't appreciate it. I live 1 block away and I don't appreciate it." Quote, "They didn't break the law, and if they did it somewhere else again, they wouldn't be breaking the law," says Cynthia Sims, a spokesperson for ABRA. Sims adds that ABRA may take a closer look at catering license, but for now, the Grey Goose Mansion is completely above board. But, quote, "When they discovered it, it was like, wow, they really thought outside the box and made this work," Sims says. So with that, I call Afshin Matagi to the stand for a few
I would
questions.
object and I would object.
I'm sorry. And for you have so noted, Mr. Sealer, that I mean, one thing that I'm trying to do is to preserve a record. So if this matter is appealed, based on whatever decision that's made by the board, the Court of Appeals will have a full record and to make a determination. So that's that's the basis of making some of the determinations that have been made within this case, is to preserve the record.
Respectfully, Mr. Chair, that's why I did not interrupt, so that the record would be complete, but I would like the opportunity for the record to object and move to strike.
So noted. All right. Go ahead, Mr. Klein.
Swear the witness, Mr. Chair.
Who is the witness that you're calling, sir?
Afshin Matagi.
Mr. Matagi, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
Yes, sir.
Go ahead.
Mr. Matagi, what's your connection with Flash Catering?
I'm the operator of Flash Caterer.
You were involved in the decisions concerning the prior offers and compromise, is that correct?
Yes, sir.
And you agreed to accept offers and compromise?
Yes, sir.
Why was that?
But when we were made to understand that, we needed to provide, get a C of O for the location, and, it was obtained, this was explained to me as, the major part of what we were doing wrong to help correct the issue.
Okay, and did you hold any events at that warehouse before the C of O was corrected?
Before, well, not only the ones that we were that we got the violation for.
Okay, but after the violation, and before the C of O was corrected, did you hold any events there?
No.
Okay, now, are you the only catering company that works at that location?
I'm unaware of if I am or not.
Okay, but do you operate there continuously, daily, 3 to 6 times a weekend, as it was testified to?
No, that's not true. The events there were infrequent, and we were not always, we were hired to do the events as needed, but there were definitely not that many events there.
Okay, and when this happened on October 21st of 2022, did you make another change to your operation or another change to how you conducted these events at that point?
But at that point, they further advised to actually get 1-day liquor licenses, which then, we done for the months of October and November.
Okay, and did you pull several 1-day or temporary licenses for
Yes.
events there?
Yes, there were, I think, 6 pulled in October. That's how many events there were there, and maybe about the same number, throughout each month throughout the end of the year.
Is it your testimony that you attempted to comply with the law as you understood it throughout the running of all these events?
Yes, I say everybody that, every time that we were pointed out that, we need to do something different, whether it was, getting a C of O or getting a one-day license or, providing fire exits and so forth, we complied immediately.
Okay. Those are all the questions I have. Thank you.
Mr. Filler, do you have any questions for the witness?
Yes, I do. Mr. Chair, members of the board, may it please the board. Mr. Magadi, am I pronouncing that correctly?
No, but that's okay.
Well, please, how is the correct pronunciation?
Mataki.
Mataki?
Yeah, thank you.
Thank you. You have a website for Flash, correct?
Yes, sir.
And it's www.flashdc.com?
Correct.
Objection. We're well outside the scope of direct.
I ask a little bit of leeway because this is very relevant to what he was directed about.
I don't care how relevant it is. I've been denied my right to make a motion to dismiss that would be promptly ruled on. I purposely kept my testimony tight, and I would object to examination beyond beyond the scope of direct.
I would also note that this is not recross, this is cross-examination of the licensee in this matter. And I believe that inquiring about his operation is well within the scope that I am entitled to at this point.
It's beyond the scope of direct because I didn't even need to put him on the stand.
But you did put him on the stand, sir.
For very limited purposes, not to be asked everything in the world.
But I don't believe that. I'll give the government some leeway, but I'm going to overrule your objection. But as stated, Mr. Sela, the witness testified to some general topics, so you are somewhat limited in the questions that can be asked.
Absolutely. Yes, Mr. Chair. Well, strike that. You said that you stopped holding events until you got a new C of O. When did you get a new C of O?
I have to go back and take a look. I'm not sure.
Do you know the month?
I am unaware.
Well, how many months were you shut down?
I believe about 3 to 4 months.
Okay. And you held no events then between February and somewhere in the May, June range?
Probably until May. I'm not sure, maybe June. I don't remember, to be honest with you.
And after that, you continued hosting events, correct?
We catered the events there.
Okay. And you advertised for those events?
We did not advertise for those events.
I am showing you permission to share my screen.
Mr. Orty, and can you please allow Mr. Thieler to share his screen?
Access has been granted.
I'm about to show you what was marked as Government Exhibit 2 for the anticipated trial in both, actually, of the previous 2 cases involving these charges. So this would have ended up being government.
We're not sharing your screen, sir.
I wanted to
okay
there before I shared my screen. But it would have been Exhibit 2 in both case numbers 22-251-00002 and 22 CMP 00018. And it is a screenshot from the website www.flashdc.com.
Objection beyond the scope of direct. It's from the previous case. Relevance, timing, hasn't been previously disclosed. What else? I mean, here I am. I put on a witness for very specific purposes, and somehow that opens the door for opposing counsel to use exhibits that were not even listed and provided in advance. I mean, this is an ambush and is improper, and I strenuously object.
It is rebuttal evidence, Mr. Chair, and specifically it is being offered to rebut the contention that Mr. Madati, and I apologize if I'm not pronouncing it correctly, but that the licensee was not operating events as frequently as the government alleged, and his contention that they were only operating one event a week or 6 events a month or what have you. Specifically, this is his calendar from his website from 7/3, so July 3rd, 2022 through October 8th, 2022. And it is rebuttal evidence that need not be disclosed in advance because, frankly, I could not have foreseen the allegation that he was operating so few events and had no basis for disclosing that evidence before today.
I'm gonna overrule the objection.
I am now sharing Government Exhibit 2 with you. Do you recognize this website?
Yes, sir.
And is it your website?
Yes, it is.
Now, I see here on your website on Friday, July 8th and Saturday, July 9th, a total of 3 events. Is that correct?
That's correct, sir.
And then on Monday, July 10th, there was an event.
Correct.
And on July 14th, 15th, 16th, there were 4 events.
Correct, sir.
And on July 17th, 21st, and 23rd, we have 5 events.
That's correct again.
So is it fair to say that you were operating 3 to 5 events per weekend, per week?
At my brick and mortar location, yes, sir, at 645 Florida Avenue. That's the calendar for our brick and mortar location called Flash. This is irrelevant to Flash Catering.
So these events were not being held.
No, sir.
Then please describe when you would apply your catering license.
When we were hired to cater an event.
Well, who would hire you?
Somebody who's having an event at that location, at whatever location, whether it be a wedding or a party or an office event.
In 2022, how many clients did you have?
Probably 3.
All right. And I assume that Mr. Isha was one of your clients?
Yes, sir.
And he would have you cater events at his warehouse?
Yes, sir.
And you ran them in the same style that you ran your brick and mortar events, correct?
No, sir. We don't serve food at our brick and mortar location.
All right, that's fair. Other than the food, though, the musical events you ran in the same manner as you ran them at your brick and mortar place, correct?
Objection. Objection. Relevance. What does this have to do with 23 DCMR 2000.1?
The manner of operation is highly relevant to how we're discussing the caterer's license.
Mr. Chair, can we look at 23 DCMR 2000.1, please, in terms of what it says? We are so far afield here.
What section?
I mean, first, it says that it authorizes a licensee to sell, deliver, and serve alcohol for consumption on the premises of a catered event. Check. At which the licensee is also serving prepared food. Cater is a business entity engaged principally in the processing, preparation, and service of food products, which is prepared especially for the customer for an event, and the service of alcohol is incidental to food prep. 3, shall not be granted or maintained by entities which only serve snack items. And then it defines what snack items are. I mean, this whole notion of a continuous operation being prohibited, even if we know what that is, that's nowhere in 2000.1. And that's the whole point of the news article, is that maybe we don't like it. Maybe some people don't like it. We'll change the law then. But he's being asked has nothing to do with what's set forth in 23 DCMR 2000.1, which is the section of the regulations which the licensee is charged with violating. It's completely irrelevant.
But all that was being, at least at this juncture, it was a clarification. I mean, the witness was being impeached based on the calendar. At least maybe I'm lost, but the government put forth the website for what they thought was the calendar for flash catering.
Right.
And clarifications, and the witness testified that this was not the calendar for flash catering, but the calendar for flash, which is a separate entity. And I think we're just getting some clarification between the difference between the flash catering and flash. I thought that was just some clarification that was being.
It's fine.
All right. Okay. Go ahead if you can answer the question, sir.
I don't remember the question.
The question was, are the musical events that are held when you cater events for Mr. Isha, are they operated, run the same way that you hold your event in Florida at?
I'm sorry, are they operated or run what?
In the same way that you run your musical events at the Florida location?
No, we don't. At the Florida location, we hire the music, the talent, and everything. As a caterer, we're only providing food and beverage services.
Now, you were advised you had to get one-day liquor licenses, and you say that you started to adopt that practice, correct?
Yes, the location, yes.
But you had also been advised that you were violating your caterer's license in previous visits by Inspector Puente, correct?
I wasn't told that we were violating the catering license, but we were told that we weren't using it in a proper manner, which I disagreed with or did not, agree with 100%. Not as it had been explained to me.
Now, you were charged twice for operating without a caterer's license, correct?
I believe we were charged.
Objection. Fact not in evidence. He has a catering license. He was not charged with that.
I apologize. You were charged twice for operating beyond the scope of your caterer's license, correct?
I believe that that's correct.
Okay. And you spoke to Investigator Puente on February 12th, 2022, correct?
That is correct.
And he advised that the operation of this nightclub was beyond the scope of your caterer's license, did he not?
Objection to the characterization as to nightclub, assume facts and not in evidence, and contrary to the testimony that we've heard thus far.
Rephrase your question, Mr. Seal.
Investigator Puente told you that operating the nightclub in the manner it was operating is beyond the scope of your caterer's license, did he not?
Same objection. It's not a nightclub. It's not what it is. We have nightclub licenses. That's the legal definition of nightclub. That's all there is.
Mr. Klein,
Fuente said.
and that is the clarification is that what Mr. Puente said to him, whether or not it's the correct interpretation of the law. All the attorneys asking, is this what Mr. Puente told you? The investigator told you when you had the conversation with him. He can say this is not. He can. So I'm overruling the objection. He can answer the question if he can by saying what his view is. I'll give you an opportunity to ask. I'll give you an opportunity, sir, to on this particular question. I'll give you an opportunity on this rebuttal to ask questions.
Thank you.
Yeah, Mr. Fuentes also, identified that or clarified that we weren't selling food, and that's what made it beyond the scope of our license, which we actually were.
How well do you remember that conversation?
Frankly, not, I remember it pretty well.
Okay. Even though it was 9 months ago?
Like I said, pretty well.
And Investigator Puente found that you were intoxicated during that conversation. Did he not?
That was his opinion, sir. I was not intoxicated.
Okay. And you were the ABC manager in charge of Flash Catering at that time, correct?
For that event, yes, sir.
And you were not present during the February 26, 2022 event, correct?
February 26, 22 event. I can't remember if I was or not.
Well, regardless of whether you were or not, you did read the investigative report after you were charged, did you not?
Did I what?
Read the investigative report after you had been charged?
Yes, sir.
Okay. And you accepted liability for the charge when you accepted the OIC, correct?
Objection calls for a legal conclusion and beyond the scope of direct. He's not a lawyer. He doesn't know what it means when you accept the OIC, other than he made a deal.
If he doesn't know what it means, then I question the representation.
All right, I'm going to sustain the objection. Let's move on.
You have 2 primary tier violations in your investigative history for operating beyond the scope of your caterer's license, correct?
Objection. Wrong as a matter of law. It's one primary. That's how they're calculated. They were resolved in one OIC, which counts as one primary.
So, if I may, Mr. Chair, they are 2 primary. They're both first primaries, but they are 2 separate primary charges.
If you're trying to make a distinction, I think
beyond the scope of direct, Mr. Chair.
That is, I thought I allowed certain questions because it was as rebuttal. So I'm not sure if this. I'm sustaining the objection because I allowed certain questions to be asked because it was per rebuttal. We've now beyond rebuttal. So if you're cross-examining the witness on direct, then that's where we should be now.
On direct examination, you testified that you tried to comply with the law, correct?
Yes.
Okay. So you had previously 2 separate primary tier violations for operating beyond the scope of your caterer's license, correct?
I believe so.
And you said that you changed your operations by selling food with the alcohol, correct?
No, we've always sold food, sir.
Well, you didn't sell food with the alcohol on February 12th or February 26th, 2022, did you?
Yes, we did. We've always sold food, sir.
You didn't sell sufficient food with the alcohol on either of those 2 dates, correct?
Objection, argument, and I've asked and answered.
No, he is drawing a distinction saying he always sold food. And in fact, as I think about those reports, he did sell a modicum of snacks and therefore he was telling the truth. However, he did not sell sufficient food to be served with the alcohol because he was charged with those 2 violations and he accepted an OIC on both counts. So it is a fair line of questioning.
It's way beyond the scope of the rat. Mr. Chair, how long does this fishing expedition get to go on?
Chair, I am explicitly asking what steps he took to allegedly comply with the law. This was a direct question that he was asked on direct, and I am exploring that question very specifically.
I'm going to overrule the objection. I'm looking at the investigative history, and there's some distinction within the charge itself. So I will allow I'll overrule the objection.
Okay, sir. You altered the type and amount of food that you served with your alcohol following the first 2 charges, correct?
We sold the same amount of alcohol, food, with, in the previously as going forward. Inspector Puentes was under the impression that we were not selling any food at all.
Is that so?
That is so, sir.
And you contend that you were selling food.
Yes, sir.
So why did you accept liability for violating charge 2 of both those previous violations?
We were operating without the C of O, and I understood that to be a mistake.
Okay, well, I certainly can understand that. And that was charge 4 in both. Yeah, that was charge 4 in both of those cases, correct?
I believe so.
And in both of those cases, that resulted in a warning.
Mr. Chairman, I object. Like, what is this?
All right.
What are we doing here?
Mr. Chair, I want to know what changes he made to comply with the law. He just
testified to that.
The only thing he changed was updating the certificate of occupancy for which he got a warning. That means he did not change his manner of operation that resulted in charge 1 or charge 2 for which he paid fines. This is absolutely appropriate impeachment across examination.
Mr. Chair, I will never enter into an OIC again. I will never do it. If this is what's going to happen when entering into an OIC, I will never do it again. I will never recommend a single client trade-off charges in any manner if this is going to be allowed. I'll not under my watch. It won't happen. This is outrageous. It's an offer and compromise. That means there's trade-off. Some things are dismissed. Some things you admit to and you pay a fine. Some things you agree you'll get a warning on. Mr. Cello knows this. This is outrageous.
All right. I'm sustaining the objection. I think that we've had enough probative on this issue, and I think we need to move on to the decision that the board needs to make a decision whether or not, based on what's on the charging documents, and whether or not the government has met its burden in providing sufficient evidence that the licensee is guilty of the infraction charge. And so that's the case in point. And so I think we've moved afar from that, from where we need to be. So let's get back there and let's move on.
No further questions at this time.
All right, thank you. Mr. Klein, brief.
I don't have anything further.
Thank you. Do you have another witness, sir?
I do not. We rest.
All right.
Board questions?
No, we had moved. I'm sorry. We had moved beyond. The board had asked the questions already, Mr. Short. So it was an opportunity for the attorneys to ask questions. So unfortunately, this has gone on so long, but the board had its opportunity to ask questions, and so therefore, questions were being hold on. Did the board, and let me, because it's been a long time ago. Was the board allowed to ask questions of the licensee? Yes.
That was my first cross-examination, Mr. Chair.
I'm that was your first. So therefore, the board was not given an opportunity to ask questions of the licensee. I apologize if we've been going back and forth. So Mr. Klein, I'll ask you, was the board allowed to ask questions of your client?
I don't recall. I don't think you did, but I don't know if you're given the opportunity. I can't say. I don't know one way or the other.
All right. I believe that Mr. Short has a question. So therefore, since I apologize, Mr. Short, but because we've been going back and forth so long, I thought that the board had an opportunity. All right, so if you have a question, Mr. Short, go ahead, please.
First of all, thank you very much, and I appreciate you allowing me to ask questions, Mr. Chairman. Mr. Motaki?
Yes, sir.
What, again, refresh my memory, what is your particular role with Flash and with Flash Catering?
I'm the owner of and operator of both.
What was at 2101 New York Avenue before you start renting or obtaining use of that particular address?
I believe it was a warehouse space. I'm not 100% sure for what the use was.
Did anyone ever use it as a venue for catering or use it for a nightclub prior to you taking use of it?
I have no idea.
What kind of construction did you have to do to that address prior to you opening up?
I was just the caterer. I was not involved in the build out or of the space.
Okay. You mentioned earlier too, or it was mentioned earlier, that fire inspections were done on the location. Is that correct?
That's correct.
What did the fire department or fire marshal direct you to do, and what did you do?
We have a fire what do you call it, plan, a fire escape plan, and as well have an active fire alarm system there.
So did you have those things when you were given that warning or that citation by the fire department?
They were not in place. Actually, they were not in place. The fire alarm system was in place, but there was not to the requirements of the fire department.
How many people were there that night when the fire marshal came? How many people did you have in your venue?
At that night, I would estimate between 500 to 600.
And under your own testimony, the fire alarm system was not functioning correctly, correct?
It was functioning correctly. It was not up to the standards, that the fire department would require. There were some modifications they asked for.
I can understand your answer, but again, if you were doing it legally, your fire alarm was legal, you would have never been cited by the fire marshal's office. Is that a correct? Yes or no?
I would say that's, it was multiple. It was also, they didn't like the fact of what do you call it? The strobes. There weren't enough strobes for them. So, but the system itself was functional, but yes, it was not up to their standards.
And maybe you know the answer to this, or maybe you don't. Had there been an emergency event and the fire alarm system malfunctioned, would you have had any responsibility?
I would assume yes.
So if someone got injured and you were operating, you admit that you put the public in danger. Is that correct?
I would have to say yes.
Thank you very much for your honesty and for your answer. That's all I have, Mr. Chair.
Thank you, Mr. Short. Any other questions by any other board members? Mr. Philo?
No recrossing on that.
Mr. Klein?
I don't have anything.
Thank you. Do you have another witness, Mr. Klein?
I do not, thank you.
DRS?
I did.
You need a break to do closing? Or do the parties need a break prior to closing, or are they ready to go to closing?
I'm ready.
Who's ready?
Go ahead, Mr. Philo.
Before I begin, I do request to reserve time for rebuttal.
Yes, sir.
Thank you. Mr. Chair, ladies and gentlemen of the board, may it please the board. This case centers around what it means to be a caterer. How is a caterer defined? That's what we've been arguing about this entire time, and that is what this case centers on. A caterer is defined as a entity, partnership person who, and apologize, I'm pulling it up now, who is principally engaged in the processing, preparation, and service of food products, which it has prepared, especially for the customer for an event, and the service of alcoholic beverage is incidental to the food preparation and service. In this case, Flash Catering was not operating as a caterer. They were operating to run a continuously operating nightclub at a brick and mortar location. They were not hired for events. They were continuously running this nightclub, and we've heard no significant evidence to the contrary. Certainly, Mr. Mugati challenged the amount of days that they were operating, but not the period of time, not the continuous nature of it. Instead, what we have heard arguments on is that the licensee could not possibly know that the board was challenging their method of operation, could not possibly know that the way that they were operating this nightclub was in violation of their caterer's license. They did not have notice. You received a newspaper article that supposedly shows they did not have notice, despite that being for a very different set of facts 13 years ago. What notice did they have? Well, they had multiple show cause notices, 3 of them, in fact. This exact charge for this exact behavior was put forth in case number 22-251-00002 and 22 CMP 00018. And the licensee testified that he, quote, tried to cooperate with the law, that he changed his operations. How did he do that? He told you. He went out and got a certificate of occupancy. Now, on that charge, he received a warning in both those prior cases. He also said that he did nothing else, that he did not make other changes. Now, I didn't get into this fully, but he was charged and accepted an OIC for the method of his food preparation and the amount of food and type of food that was sold. And yet, he did testify that he made no changes to that manner of operation, despite a finding of a primary tier violation in each case. He also was charged with operating beyond the scope of his caterer's license because of the continual nature of the operation of this nightclub in a continuous event manner, ongoing with plans to continue for about a year. He made no changes to his manner of operation. He made no changes until the third charge, when he started to get single day liquor license permits for his events. Notably, he has not been charged since he started to get individual single day events, because the manner of operation was changed, because it was no longer in violation of the code. Now, Attorney Klein has repeatedly raised that there are no facts that we cited whatsoever to say that this is an inappropriate use of a caterer's license. And that's simply not true. It is the continual, ongoing operation of a nightclub, day in, day out for a year, involving multiple bars, DJs, live events, dancing, and doing so in continual operation in that manner through the end of December 2022. That is what was cited as a violation of a caterer's license, running a nightclub without the caterer's license, without a nightclub license, with a caterer's license. And he was notified of this on February 12th, 2022 by Investigator Puente. On February 26th, 2022 by Investigator Puente. He accepted responsibility for it by signing the OIC on September 14th, 2022. And then he was told again by Investigator Puente on October 21st, 2022. And only after that, finally, after that, did he change his manner of operation. Why did they do it? Well, according to the quote by Investigator Zollikofer, they did it to make money and to stay relevant in the business. And they intentionally continued to do so through December because they were just getting fined. You know what? When Attorney Klein is about to discuss a loophole in the system, well, they found a loophole. They made a lot of money over the course of that year. And they've paid $4,000 fines and whatever fine this board issues today. And that's it. I don't know how much money they made, but I'm sure it was a good deal, and I'm sure it was a good loophole for them. But let's consider why we require different licenses. Why does this board require a nightclub to have a nightclub license? Well, it requires it for safety. It requires it so that the public knows what it should do for a protest hearing. Does this board expect and intend for people unlicensed to operate nightclubs continuously for a year while using somebody's caterer's license as their manner of operation, to avoid protest hearings, to avoid public comment in such a manner for continuous operation? No, protest hearings are part of opening new nightclubs in the district. And nightclubs are required to have security plans. Why? Because they are a uniquely dangerous environment if they are not properly run and secure. Caterers don't need to have security plans. As Attorney Klein mentioned earlier, other people can operate in a manner similar to a nightclub, but only if they get endorsements. They need a live music endorsement. They need a dancing endorsement. Why do we require that? Just because we feel like being bureaucrats? No, this board requires it so that the public can comment so that protests can happen and so that the board can ensure that these operations are occurring in a licensed, safe manner. By continuously operating a nightclub with only a caterer's license, the licensee avoided all of the checks and balances expected of this board and of the district. There are reasons for these licenses. There are reasons that we don't just have a single do anything license in this district. And by flaunting the rules, by knowingly, continuously violating the rules for months on end, the licensee has spat in the face of those safety precautions. This is a situation in which this board must weigh the safety of the district, the purpose of the license, the intent of the law. I submit to you that the licensee knowingly and dangerously violated that intent again and again, and that this board should not dismiss the charge. Instead, it should find the licensee liable and issue a fine that appropriately weighs the intentionality behind this ongoing violation. Thank you, and I reserve my time.
Thank you. Mr. Klein.
Mr. Sello weaves a good tale. However, it seems to ignore the law and the facts that have been proven in this case. He would lead you to believe that this operation was wholly dangerous. But lo and behold, if they got a one-day license, it's fine. So this whole notion and hysteria that somehow this licensee is evading the law and avoiding the requirements that are set forth for on-premise licensees, apparently it's okay if you get a one-day, but it's not okay if you do it under a catering license. Now, let's first talk about the facts, then we'll talk about the law. In terms of the facts, there is no evidence that Flash Catering ran a nightclub operation in this warehouse with any frequency over a year. You heard Mr. Matagi's testimony, which is unrebutted in terms of what he did. There was lots of innuendo about, oh, they're doing events 3 to 5, and apparently they based it upon his brick and mortar website. You know what else they based it on? Exhibit 14. Take a look. It's Exhibit 14 to the investigator's report. Apparently, it's a web page from Warehouse 2101, and it talks about this space being available and being curated and operated not by Flash Catering, by new androids. That's not Flash Catering. The government is confused as to what went on here and what Mr. Matagi's role and what Flash Catering's role was in the operations. He testified, again, unrebutted, that he was responsible for the catering. If you look at the certificate of occupancy that's attached to the report, it's not issued to Flash Catering or to Flash or Mr. Matagi. It's issued to a separate entity. So the operation of the warehouse was separate and apart, operated as an event space, and this business, Flash Catering, was brought in as a caterer. Now, there's been lots of words and lots of testimony, and there was even in closing discussion about what the policy should be, what the intent of the law should be. Well, the first thing we have to deal with is the plain language of the law. What's prescribed? What's required? That's what we have to look at, not what we think the law should be. And I have to correct Mr. Sello, because he said the board doesn't require endorsements because they're not needed. No, the board doesn't require endorsements. The board didn't pass the law. The council passed the law. So it's the council that determines what's required. And then it's, of course, the board's job to interpret the law. But the board has to interpret the law as written and apply the law as written. Now, even the investigator on cross conceded, yeah, they found a loophole. Well, what's a loophole? The loophole is something where people may not like it, but it is in accordance with the law. And the reason that we used the article concerning the Grey Goose Mansion, because that was exactly the case there. And Mr. Sellers says, oh, it's completely different. Read the article. You'll see it in different. They were doing this Grey Goose vodka sponsored mansion every weekend. The community was concerned about it. And the chair of the ABC board, again, not binding upon you, doesn't speak for the board, but said, yeah, I don't like it, but they can do it. The spokesperson for ABRA, now ABCA, says they didn't break the law. And if they did it somewhere else again, they wouldn't be breaking the law. Has there been any change in the law since then? No. The only change that there's been has been in the Office of Attorney General, where they decided that this case was worthy to prosecute. Now let's talk about what the law says, because that is what this case is about, is what is in the statute and what the requirements are. This licensee is charged with violating DC Code 2000.1, which is in the municipal regulations and relates to the operation of a caterer. And we went through it before, but I think it's important enough where we go through it again. Remember, they're charged with violating 2000.1 of 23 DCMR. That means you, as the board, have to find something in 2000.1 that they violated. Now, guess what's not in 2000.1? Continually operating a nightclub. That's not in here. What's in here? It says, and we did it before, but I think it's important to do it again. The caterer's license shall authorize the licensee to sell, deliver, and serve alcoholic beverages for consumption on the premises of a catered event. Check. That's exactly what the licensed caterer was doing. At which the licensee is also serving prepared food. There's no issue about that. There's no allegation. And in fact, Mr. Sello would have you believe they didn't make any changes from their previous operation. There wasn't any suggestion here that they weren't serving prepared food. So either the investigators got it wrong the first time, or there was a change made, because they didn't charge it the second time. We go on to in 2000.1. A caterer is a business entity engaged principally in the processing, preparation, and service of food products, which it is prepared especially for the customer for an event. Exactly what went on here. There's no allegation to the contrary. And the service of alcoholic beverages is incidental to the food preparation and service. Now, there's been some discussion over the years as to whether that incidental to the business operations of the caterer or the particular event. In this case, it doesn't matter. There's no allegation that the alcoholic beverages were not incidental. No one said that. And then lastly, a caterer's license shall not be granted to or maintained by entities which only serve snack items. Snack items include, but are not limited to, potato chips, popcorn, pretzels, nuts, cookies, and candy. That's it. So that's what they're charged with violating. So which of these provisions and I've asked this. I asked this before this case came before you of the government. I've asked it throughout this hearing. Which of these provisions is it that they violated? Because I can't figure it out based on all the testimony that we've heard. What I've heard is, well, we don't like what they did. They're continuously operating a nightclub. Although what they were doing with these events, and I think this was established by the testimony, is no different than what they would be doing if there were weddings being held or fundraisers, birthday parties, any number of special events. There's no allegation that this is any different. The investigator reluctantly testified that, yeah, people might drink alcohol at weddings. They might hear music. They might dance. I think his experiences are a lot different than mine in terms of weddings. Maybe I'm older and have been to a lot more weddings. But I think we all know that's fairly common. And that's exactly what's alleged went on here, is that people were dancing, they were listening to music, they were having a good time, which is the same thing they would be doing at a wedding, a birthday party, a fundraiser. But 2000.1 doesn't say it has to be a wedding. Doesn't say it has to be a fundraiser. Doesn't say that it has to be a birthday party. It only says it has to be a catered event. And the unrebutted testimony is that Flash Catering was brought in by the operator of the warehouse to do the catering. Now, much is made about, oh, he knew he was in violation. Yeah, he kept changing course and saying, okay, if I'm doing it wrong, let me do it right. All right. And this whole discussion about the OICs is offensive because we all know that offers and compromise are part of this process so that things are more efficient, so we don't go to hearing on every single case. And the licensee makes decisions. Sometimes, and in my experience, sometimes they didn't do anything wrong. But you know what? Cheaper to pay the fine than to pay me. And that's a fact of life. I tell my clients all the time, the difference between being right and proving it, it's called legal fees. And these people are in business, so they make a business decision. Maybe Mr. Sully doesn't like that, and they're branded with the scarlet letter because they agreed to an offer on compromise. But I hope that that's not the position that this board's going to take in this case or any other. Because again, as a lawyer advising clients in the future, I would have to think really twice about ever recommending again that they do a staff settlement or enter into an offer on compromise, because a lawyer like Mr. Sello will come along and say, see, you're a bad guy. Look what you did. You admitted it. So you knew what you were doing. You're recidivist. It's terrible. Now, in this case, that's not even true. Mr. Sello argues, well, they're all the same. No, they're not all the same. In the first two cases, there was something of grave concern. And I know Mr. Short would raise it if we went to hearing, which is the C of O is not appropriate. And Mr. Matagi was like, so the fact that they were given a warning for that, who cares? The case was resolved. And in Mr. Matagi's mind, that was the big issue. Because as Mr. Short points out, that involves public safety. So yeah, that's what he was concerned about. He was concerned about public safety. Warehouse needs to get the C of O right. Otherwise, we're not going to do any more events until they do. They ultimately did. And as far as he was concerned, the other issue potentially being food, which apparently wasn't an issue going forward because they weren't charged with it again, he made a change. And then they come in again in October and they say, nope, you can't do it this way. Now, we don't agree that they can't do it this way for all the reasons that we've argued today. But guess what Mr. Matagi did? He said, all right, then fine, we'll just get 1 days. Will that make you happy? And they said yes. So we got 1 days. So this whole notion that he just barreled on down the road, oblivious and seemingly impervious to the requirements of ABCA or the board, is just woven out of whole cloth. It's just simply not true. It's not supported by the facts. And let me talk about why this whole notion of asking you to apply the law as written and not make it up as we go along and not do 180 from what was done in the Grey Goose Mansion case, albeit 13 years ago. And that's because of the case that I alluded to earlier, which is relates to the loitering and vagrancy law. And that case, Papa Cristo v. City of Jacksonville at 405 U.S. 156, 1972, it ruled on a situation that we've talked about many times, which is loitering and vagrancy. And the Supreme Court said, well, no, we can't let this go on because it's so vague. What's going to happen? Well, the government's going to go after people they don't like and let the people that they don't have a problem with go. And the police officers on the street will use their discretion. They'll arrest people of a certain race. They'll arrest people from a certain neighborhood. And the rest of them they won't fool with. That's why it's important that we are a nation of laws, which means we don't look at things in the present and look back and say, yeah, we don't like that. That's illegal. You can't do that because we don't like it. Instead, what we do is we apply the law as written. And in this case, the law as written is 2000.1. And that's the only thing the licensee has been charged with. So if we start hearing about 25 DC code 113 and what have you, he's not charged with that. And we're not on notice that he's charged with that. The only thing we're on notice that he's charged with is 23 DCMR 2000.1. I went through with you what is in there. And it's important to note what is not in there, which are all the things that Mr. Sello is arguing, which is, well, but it looks like a nightclub. Okay, well, it doesn't say, but you do all this, but if it looks like a nightclub, you can't do it. It doesn't say that. And in fact, the ABC board recognized that in 2010 and made public statements. There was a fact-finding hearing, and I ask you not to rely on the public statements in the news article, because I share, and I've expressed it to this board many, many times in other cases, consternation about using press clippings in a contested case. It is not something I do lightly. I don't think it's right. But in this case, when the ABC board says, well, this is what it is, and there's nothing we can do about it, and the spokesperson for the agency says exactly the same thing. She says exactly what the investigator says. Well, it's a loophole, and guess what? If the council wanted to close that loophole in the last 13 years, they had ample opportunity to do so. If the board with the assistance of the agency pushes an omnibus bill every 2 years, if the board thought it was a loophole and wanted to close it, there were plenty of opportunities. So if we don't like it, then let's change it. But don't punish people who complied with the law as written and say, yeah, we don't like it. So yeah, you may have complied with the law, but it still looks like you ran a nightclub. All this notion about, well, yeah, you need an entertainment endorsement. Now, there's one other point, and I want to make sure that I don't lose sight of this. So the argument is that these places can run and they can be out of control and there's no check on them. Well, that's just not correct. It's not our law. And there is the provisions in the code for what is called a catered site protest. So what happens is if you have this warehouse and it goes on and there's events and they have a wedding every other weekend, or they have the events that were run by Flash or every weekend or what have you, then under 23 DCMR 2008, the protestants, who are the same protestants that you see almost every week in regular license proceedings, ANC, Group of Five, Chief of Police, and the others that are authorized incorporated citizens associations, they can protest the site and say, yeah, we don't want this in our neighborhood. And guess what happened in Grey Goose? Guess what the end of the story is? The neighborhood protested the catered site. And that's in your records. You'll find that. It's a matter of your public records. So the system worked. And the idea that these caterers could go on forever, as suggested by Mr. Sello, and there's no controls on them, and they're operating outside the law, it's just nonsense. It's not the way it works. It's not what's in the law. There are guardrails, and there's a system in place. Is it perfect? I don't know. I leave that to you, and I leave that to the council. But if it's not perfect, the way to fix it is not to punish people for when they've complied with the law. It's to go change the law and say we need more. And the board has not been shy about doing that when it's needed. And if it's needed here, who knows? We may even in wearing my other hat, might even support you doing it. But it's just not right. And it is not only not right, it is unconstitutional and a denial of due process to announce a new standard particularly when it's not supported by the language, that is contrary to the announced policy of the agency and at least the chair of the ABC board. And Mr. Anderson, Chairman Anderson, I respect that you say you don't speak for the board, but you know what? If you did talk to the press, and I know you don't make it a habit of doing that, people don't know that. You're the chairman of the ABC board. And when you say something, people are going to listen. And and if you say it's okay, then they're going to say, well, I guess it's okay. And if they get cited, they're going to say, wait, I don't understand. The chairman of the ABC board said it was okay. And you're going to say, yeah, but I wasn't speaking for the board. No, you're not going to do that. I mean, that's just, it's completely unfair. And fairness, and you've always been fair, and we mostly, and we appreciate that. I mean, it's important that there be fairness, and you may not like it. And sometimes I know that you see things and you got to swallow hard, and you're like, yeah, we don't really like this, but we're constrained by the law. Maybe you like it here, maybe you don't. If you don't, I would submit you're constrained by the law. They didn't violate the law. There shouldn't be any punishment. If there is punishment, well, let me add one other thing and then I'll be done. This would be a second primary tier because there's only one prior order with respect to a primary tier violation. So this would only be a second. And I just want to make sure that that's clear for the record. Thank you. And thank you, departing board members, and thank you, staying board members, for your attention today and hearing us.
Thank you. Do you wish to speak, Mr. Silla?
I do.
Go ahead, sir.
May it please the board. How could he possibly have been on notice that his behavior was wrong? How could it be possible? It could be that he accepted liability for it twice before. Now I keep bringing that up, and that's not because it's a scarlet letter, as Attorney Klein said. It's not because I think he's a bad person. It's because it answers the question. How could the licensee know that what he was doing was wrong? Know that it was violating the code? Because he was charged with it twice. He accepted liability for it twice. He paid fines for it twice. So yes, he knew. Attorney Klein brought up a lot of examples of things that are similar to nightclubs in certain respects and that a caterer can do. But one thing that was true of each and every one of those were that they were events, single events. If we look at 2000.1, what part of that was violated? A caterer is a business entity engaged principally in the processing, preparation, and service of food products, which it has prepared especially for the customer for an event. This was not a caterer engaged in an event. This was not Grey Goose Mansion, where the caterer was hired individually for each event. And those events were not continuous, were not weekly, were not the same night of the week. In our case before us, we have evidence showing that a caterer's license was used to operate a nightclub continuously and consistently throughout the course of a year. And when asked, are you going to stop? The answer was, nope, we're going to keep operating until the end of February 2020 or December 2022 when the brick and mortar opens. That wasn't done for the purpose of, we don't think we're wrong. That was, no, we know we've been charged. We know we're about to be charged again, but this is a good business and we're going to keep doing it until we can open a brick and mortar facility. They were not principally engaged in the preparation of food with alcohol being incidental for an event. This was a continuous operation of a nightclub. And as Attorney Klein pointed out, this board's job is to interpret the law as written. if a nightclub can be continuously run under a caterer's license, what is the point of a nightclub license? If this is set as precedent today, why would anyone come to you and apply to go through the hoops to get the nightclub license? Why would anyone go through the process of putting together the security plan, facing the protest hearings before they open the establishment? If this is a loophole that is an ultimate loophole and avoids any subject to board control, to the safety provisions we have for the operation of nightclubs, then it's a precedent that everyone is going to be taking up. The fact of the matter is, we have a definition of what caterers can do, and they are constrained to work an event at a time. They do not get to operate nightclubs continuously for a year. That's what this case is about, and that is why I urge you to find a violation in this matter. Thank you.
Thank you, Mr. Silo. I just want to get some clarification, and I'm not. This is not pointing out any that I'm going to vote one way or the other. I'm just looking at the investigative history, and I'm confused. So, Mr. Klein. And I know we discussed this. I just wanted to get some clarification. The case number 22 CMP 00018 and case number 22-251-00002 were these the two cases that were in the OIC?
In the previous OIC, yeah, both of these cases were in the previous OIC. There was one OIC, one order, and we talked about earlier that was a typo that was apparently corrected. And there was a typo in the OIC, and the board corrected it in its order, which I missed, and I apologize. That dealt with these two cases, numbers 1 and 2 on the investigative report.
So if the board was to find this, this then would be the second second primary tier. Is that what? Because I just want to make some. I just want to make that at least I'm clear in my mind. Whatever decision is made, that we'll know where we are in the count.
Yeah. I don't think there's any dispute about that. I would ask the board to ask Mr. Sella, but I don't think there's any dispute about that.
I'm looking at paperwork that says something otherwise. That's why I'm looking at the case history. That's why I'm just trying to get some clarification. So that's why.
As I understand the counting scheme, Mr. Chair, because both previous primary tier violations were resolved before these charges were, before the violation in this case occurred, that the board could count this as the third. That's my understanding of the counting scheme, but certainly I would defer to the board in its determination.
All right. No. If whatever, Mr. Klein, I will. I was just asking a question because I know you made it a point by saying in a second I saw something, I said something else. Whatever decision that we make that's made by the board, we will consult with legal. And this is Donovan Anderson looking at a document and seeing something. Whatever decision is made by the board, the board makes a decision which is consistent with the law, and legal provides us, our legal office will provide us will clarify the law to us, and will clarify the count to us to ensure that whatever decision that we make is supported by the law and the statute. Okay,
Mr. Chairman, you put me in a very difficult position.
Mr. Klein,
what is that document? We're in a contested case hearing. If we're looking at something else, I want to part of the record.
No, I'm looking at the investigative history, Mr. Klein. And so the investigative history that I have, it appears to me it's a third. And that's why I was asking you. I'm looking at the investigative history. That's why I was asking you. Were these specifically two cases that were part of the OIC? Because if you look at the investigative,
if I can clarify, if you look at the investigative history, specifically charges 1 and 2, they both reference board order number 2022-663. And that's where they were resolved.
And as I said before, just looking at investigative history, it says 3. It would appear to be 3, but that's why I'd asked a clarification that both cases were part of a board order, an OIC. So therefore, all right, I just want to make, because I know in your closing, you said that this would be 2. So I just want to be clear, but that no way indicates how I'm leaning toward this case. Okay. All right.
Got it. Thank you.
Thank you. The case is now closed. I guess let me ask the parties, do the parties wish to do proposed findings of fact and conclusion of law, or do they wish to waive that?
Government's willing to rest on oral argument.
Same with the licensing.
Okay, thank you. Well, the board then will issue a decision within 90 days. All right, so hold on. Hold on a minute. As chairperson of the Alcohol, Beverage, and Cannabis Board for the District of Columbia, in accordance with DC Official Code Section 2575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 22 CMP 00084/catering pursuant to DC Official Code Section 2575B4A of the Open Meetings Act, and deliberating upon case number 22 CMP 00084/catering for the reasons cited in DC Official Code Section 2575B13 of the Open Meetings Act. Is there a second? Mr. Cato and Ms. Henson, a second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. As it appears that the motion has passed, I hereby give notice that ABC Board will recess this proceeding to hold a closed meeting pursuant to Section 2575 of the Open Meetings Act. Thank you for your presentation today. Have a great day.
Thank you all, and thank you again to the departing board members. I'm glad we gave you an exciting one to go out on.
All right.
Thank you.
Okay. Thank you. Take All right, now we're going to do the legal agenda. The first matter on legal agenda is review of offering compromise in law for hearing dated October 26, 2023 for case number 23 CC 00012, Sammy's Liquors license number 108222. The offer in compromise is as follows. Charge 1, violation of code, failed to minor violation of code 25-781. The offer in compromise is as the prime material violation. The fine is a $3,000 fine payable within 30 days, or the license shall be suspended indefinitely until the fine has been paid. Part 2 of the charge, the license shall be suspended for 10 days, with 4 days to be served and 6 days stayed for 1 year. And all employees who serve alcoholic beverages in a licensed establishment complete an alcohol training program within 3 months from the OIC's date. Charge 2, fail to take reasonable steps necessary to ascertain legal drinking age. DC Official Code Section 25783. Primary tier is a primary tier violation. Second primary tier violation within 2 years. This charge has been dismissed. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Ed Grandis will second.
Mr. Short and Mr. Grandis will second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis. And Mr. Anderson, I agree. The matter passed 4-0-0. Mr. Grandis, I'm not sure if you all right, number 2 on our legal agenda, review of a settlement agreement dated October 17th, 2023, by and between Advisory Neighborhood Commission 6D and Hell's Kitchen, license number 121424. I make a motion that we approve this agreement. Is there a second?
Ed Grandis will second.
Mr. Grandis will second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0-0. Number 3, review of a settlement agreement dated March 23rd, March of 2023, by and between Advisory Neighborhood Commission 3G and Urban Grapes, license number 123788. I make a motion that we approve this request. Is there a second?
Jenny Hansen will second.
Ms. Henson, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato. Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passed 4-0-0. Number 4, review of a settlement agreement dated October 13th, 2023, by and between Advisory Neighborhood Commission 2E and Residence. I make a motion that we approve the settlement agreement. Is there a second?
Jenny Hansen will second.
Ms. Henson, I second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 4-0-0. Number 5, review of request to reinstate canceled license dated October 25th, 2023. License was canceled on October 18th, 2023, pursuant to board order number 2023-515. This is Los Compañeros, license number 103801. I make a motion that we approve this agreement. Is there a second?
Mr. Short, I
Grandis.
second.
Mr. Short and Mr. Grandis is second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0-0. Number 6, review of the request from ANC 8F to withdraw protest dated September 23rd, 2023, in case number 22 PRO 00065. Tinetees, TINETTES, license number 125278. I make a motion that we approve this request. Is there a second?
Ed Grandis will second.
Second.
Ms. Henson and Mr. Grandis will second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0-0. Let's now move to our licensing agenda. I'm now taking up the licensing agenda. On the licensing agenda, there are now I have to do this individually. All right. Review application for safekeeping of license. This is for El Torgoz, a TOROGOZ restaurant license number 072165. I make a motion that we approve this request through March 31st, 2024. Is there a second?
Ed Grandis will second.
Mr. Grandis has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passes 400. Number 2, review application for safekeeping of license. This is for Afghania, AFGHANIA, license number 118936. I make a motion that we approve this request through March 31st, 2024. Is there a second?
Jenny Hansen, second.
Ms. Hanson, second the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 400. Number 3, review application for change of hours of operation. This is the Lane Social Club, license number 121348. I make a motion that we placard this matter. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 400. I'm now taking up the supplemental licensing agenda. On the supplemental license agenda, there are the supplemental licensing agenda for November 1st, 2023. There are 2 requests on that license. I move that the 2 items on the supplemental licensing agenda be approved. Do I have a second? Mr. Grandis has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
Mr. Anderson, I agree. The matter passed 400. I'm now moving to the cancellation agenda for discussion and vote by the board. There are 2 items on the cancellation agenda for November 1st, on the published cancellation agenda for November 1st, 2023. I move that the 2 items on the cancellation agenda be approved. Do I have a second?
Ed Grandis will second.
Mr. Grandis has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 400. We now move to the cease and desist Class B licenses agenda. On the cease and desist Class B license agenda for November 1st, there are 25 licenses that the board will be issuing cease and desist order. Do I have a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 400. We now move to the cease and desist agenda retail tavern / nightclubs for November 1st, 2023. On the November 1st, 2023 cease and desist agenda retail taverns nightclubs, there are 24 establishments on this agenda. I then make a motion that all the request to issue cease and desist orders on this agenda be approved. Do I have a second? Mr. Grandis has seconded the motion. We'll have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis. And Mr. Anderson, I agree. The matter passes 400. I'm now taking up the medical cannabis licensing agenda for November 1st, 2023. On this agenda, there are 5 requests for licensing. I move that all five licensing requests be approved. Do I have a second?
Ed Grandis will second.
Mr. Grandis has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Hanson.
I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0-0. I am now moving to the board temporary license and one-day substantial change docket for November 1st, 2023. There are 24 items on this docket. I move that all the requests for licenses on this docket be approved by the board. Is there a second?
Mr. Short, I second.
Mr. Short has seconded. The motion will now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 4-0-0. I am now taking up the board's licensing and administrative docket for November 1st, 2023. On the licensing administrative docket, there are 9 agenda items on this docket. I make a motion that all the 9 requests on this docket be approved. Do I have a second?
Grandis will second.
Mr. Grandis has seconded the motion. We'll now have a roll call vote. Mr. Short.
Short, I agree.
Ms. Henson.
I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 4-0-0. We now move to the licensing administrative docket street tree for November 1st, 2023. On this docket, there are 2 applicants on this docket. I move that these 2 applicants on this docket be approved. Do I have a second?
Second.
Ms. Hanson has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passes 4-0-0. We're now at the end of our calendar and our agenda item for today, November 11th. And prior to closing the record for the day, I once again would like to thank Ms. Henson, Mr. Grandis, and Mr. Cato for their service to the board. They have ably served the residents of the District of Columbia, and I want to formally thank them for their service and wishing them all 3, as they say, Godspeed in their next endeavor. And thank you very much for your service to the resident of the District of Columbia. All right. As chairperson of, yes, Mr. Short. Oh, I thought I heard. I apologize. All right. As chairperson of the Alcohol, Beverage, and Cannabis Board for the District of Columbia, in accordance with Title 3, Chapter 405, Office of Open Government, I move that ABC Board hold a closed meeting on November 8th for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulation, and seeking legal advice from our legal counsel on the board's investigative agenda, legal agenda, and licensing agenda for November 8th, 2023, as published in DC Register on November 3rd, 2023. Is there a second?
Ed Grandis will second.
Mr. Grandis has seconded the motion. I will now take a roll call vote on the motion before us now that it has been properly seconded. Mr. Short.
Mr. Short, I agree.
Ms. Henson.
I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. As it appears that the motion has passed 4-0, I hereby give notice that ABC Board will hold this closed meeting pursuant to the Open Meetings Act. Notice will also be posted on the ABC Board Hearing Room Bulletin Board, placed on electronic calendar on ABCA's website, and published in the DC Register in as timely a manner as practical. The board has now adjourned for the day, and as I stated before, the board met in person today for the first time in over 3 years, and it was good meeting in person with our board members, and we have to do this again. Anyway, we have adjourned for the day, and I'm requesting that all board members return to executive session for further action. Thank you. Have a great day. Bye-bye.